On behalf of GAK, Your Lordship.
What about the petitioner?
I've taken concern, Your Lordship.
Okay. For what? Why it should be adjourned?
In this matter, GAK is appearing, Your Lordship.
Okay.
It's not present.
MS London Council for the London State Council appearing on behalf of Miss MSG at the London Edition Senior Government Advocate. Praise for listing of the matter. After 3 weeks.
Tomorrow, Your Lordship.
Tomorrow. Okay. Praise for listing the matter on 30th. 3007. Praise the Lord. This matters on so and so. 30th. Yes. 23. This is for what? We'll see why this has been listed for orders. Are you around in the court? You'll be here. We'll see why this has been listed. Yes.
So I have filed IA for particular charge.
You are. What do you want? Okay. On the prayer of Mr. and the counsel for the petitioner, list this matter on after 2 weeks, 3 weeks.
Your Lordship, I beg to mention item number 11.
Yes.
Lordship, in this matter, we will be filing an additional affidavit.
You are for
I'm for petitioner.
MS. Your
On
name?
behalf of and one day.
So and so, London Council appearing on behalf of Mr. B. Taba,
Yes.
Council for the petitioner. List this matter after 4 weeks.
There is an interim.
Then in that case, after 2 weeks, interim order, earlier person shall continue.
May I, Your Lordship? Your Lordship, I beg to mention item number 6, Your Lordship, on behalf of S. Tapin, Senior Government Advocate.
Yes.
This matter may be listed tomorrow, Your Lordship.
Why tomorrow?
S. Tapin is
Day after tomorrow, we'll see.
okay.
On the
yes,
prayer
Your
of
Lordship.
London State Council, list this matter on 31.
Okay, Your Lordship.
31 or 1? 31.
Organize, Your Lordship.
Your Honor, I would like to mention item number 22. Matter may be adjourned and listed on this Friday.
On the prayer of Mr.
C. Peter.
You are for
We have Joya Doji.
so and so. London Council appearing on MJ Doji. This matter after week, not Friday.
Your Lordship, I beg to mention item number 18 and 19.
Good.
Our objection is ready, but since the petitioners are students, we could not get the signature before the Oath Commissioner. Kindly, any sort that may be fixed.
You are for?
Both the petitioners.
You are petitioner, you are filing an objection.
No, our reply is ready, but we could not get signature.
On the prayer of MS,
Yes, Your Honor. Oh, why Singi?
what is petitioner or
Yes,
respondent?
for petitioners.
Petitioner, your name is here.
Yes, Your Honor.
What's your name?
No, it's not there, Your Honor.
On behalf of ESMO, London Council for the petitioner, list this matter after 2 weeks. 2 weeks.
Oblige, Your Honor.
Yes. Yes.
May it please, Lordship. Lordship, this instant
Is it within
petition,
time?
Lordship.
It's within time,
Yes, Lordship.
within 45 days.
Yes, Lordship.
When did you file this petition?
This was filed on 16th, Lordship.
15,
16th,
16 of what?
16th of July. The result, it has to be filed within 45 days from the date
I
of
don't know.
declaration of result,
I
Lordship.
don't know.
So
Is it within time?
it is well within time.
And Mr. A. Tatak Learned Counsel for the petitioner. This election petition under section 80 and 80A of Representation of People's Act 1951 has been filed, is filed by the petitioner. Questioning the election of respondent number,
Respondent number 1, Lordship.
election of the respondent number 1, namely Dr. Mahesh Sek, who has been elected as the member of Legislative Assembly. Which one? Legislative Assembly
44th AGU ST.
number 44, Teju within bracket ST Assembly Constituency. On the ground of what?
Corrupt practice of undue influence.
On the
And-
ground of corrupt practice under section 100.
Yes, 100. 101.
Within bracket 1 of RP Act 1951. The election petition, list of the election petitioner has also praise for declaration of the election to the election of the respondent number 1 as member of Legislative Assembly from the 44 Teju ST Assembly constituency as void. And for declaration of the petitioner who have been duly elected in the said election. Issue notice returnable by 3 weeks.
No, Lordship, since as per the provisions of section 87 of RPA, Lordship is aware that provisions of the Code of Civil Procedure has to be followed, Lordship. And now considering that, and as per section 86(7), subsection 7 of Representation of People's Act, where it says that endeavors should be made to complete the trial of the election petition within a period of 6 weeks, 6
Will it
months.
start the trial without the issue notice?
No, Lordship, a fixed date may be given.
That's what I'm
a
saying.
Month.
Issue notice returnable by 3 weeks, fixing the date. After 3 weeks, you just fix the date. So what is your process? You'll have to take a step.
Yes, as per
Issue notice to the respondents, huh? What?
true
Just issue notice to the respondents. How many respondents? 3
four.
respondents. Returnable by 3 weeks, fixing that at 19. 1980. We don't know. Will you fix that date? Whether 19 August.
1991.
Uh,
Nine,
The
19 May or
petitioners to take
1975.
steps.
1970.
What sort of steps should be taken?
Through register post. Lordship, I have a additional prayer. Lordship, can I be allowed to take it, dusty service as per,
So then in the to take steps for service of notice upon response of 1, 2, 3, and 4 by usual process as well as by
Dusty.
dusty within 3 days. This is the care of the registry to issue process.
deeply obliged.
May I plead your lordship? Well, the matter related to land compensation. In fact, your lordship may see the judgment and order dated 8/2/2023.
You see the order of this court, 38/05/2024. You have to address the court on the why the repeated writ petition is.
Yes,
permitted.
that was the issue, but then we could not file the contempt petition
That cannot be an excuse.
because similar matter, the same stage of land, similar matter notice has been issued and is still pending before
Why
your
not
Honorable Court.
concerned?
Because
See, if you have missed the remedy under the law, writ petition will not die.
in fact,
They are supposed to comply within 2 months or 3 months. When is the judgment?
judgment is page 30. 30 starts from page 30. And the operation portion is page 36. Page
2
36.
months.
Yeah, 2 months we are given. We have
Just a receipt of certified copy.
served the certified copy,
It's okay.
but then they have not acted upon.
They have
It's a-
acted upon, but they have not brought it to logical conclusion. That's all.
They have not, yes, they have not paid compensation
No,
yet.
there is a clear direction to determination payment thereof shall be made by respondent within 2 months.
No, they have
Period of
done
2
it.
months.
They have done it. May I
If
just
they've
take?
done it, why you are filing again?
No, they have done it, but then only the forwarding is there. But
See. Determination payment thereof.
Yes.
Payment has been made.
not made.
Then,
Payment has not been made yet.
then
So the issue was that we could have procedure with contempt petition, but then we have not filed a contempt petition.
you have
That's,
missed the pass.
that's why we file a fresh.
That cannot be a ground for filing a repetitive, writ petition.
We have filed a representation before the concerned authority. My lord, may I see the representation is page 71.
Yes. You
In fact-
filed in the month of May.
Yes,
Then-
yes, because when they have not paid the
This order was of 2023.
23. The represent,
February.
yes, representation is just is filed when the compensation is not been paid. Because they were supposed to assess and pay the compensation when they
Within
didn't
2
pay.
months.
Yes, but
You
they
have
didn't
not done
pay.
anything.
Yes, then only we missed the filing contempt. Then we file a fresh representation to the concerned authority to act upon that. So on that basis, we are filing the
Just,
writ
just to have just a question of, fresh cause of action, something like that. What direction we can give? Again, the same thing, that you have violated this.
Yes, we are praying that your lordship may pass on the basis of some judgment and order, which is passed already on 8/12/2023,
Huh?
which is passed in earlier.
It's a reason it's not maintainable.
Then we
Why
filed,
should pass,
No, we filed-
repeated order, same
no,
order,
no, we-
again and again.
we took a fresh cause of action,
Sorry,
filing the fresh representation.
sir, what do you say? Will dismiss.
My
Why
lord,
we should pass again and again, same order?
Well, we file representation, my lord. That is also pending before. So it may be, my lord, may I pray that my representation may be disposed of.
We are not here to act like a post office. You pursue your authority. Right.
But similar matter, my lord, in the case of
See, this order was of 8-2.
8-2, yes.
And it was supposed to be done within 2 months.
No, but they have to pay, they were supposed to assess and pay
Then
compensation.
in that case, if there is a non-compliance, what is the remedy? What is the remedy?
I mean, non-compliant in the sense they were supposed to assess and pay, but they have not paid yet after almost 2 years.
You are well aware, laws are not just made on the air. It has to be implemented, the procedures, certain procedures are laid down. Well, have to abide by that.
But my lord, there is a judgment, but I'm not able to take out the judgment. There is a judgment of 2000 which says that the rate petition is maintainable. So I am not able to take out that.
I'll give you 20 judgments on it.
Yes.
So you give us today,
My lord, may I give then maybe
tomorrow, we'll take it up tomorrow.
maybe on Thursday,
Tomorrow.
tomorrow. Obliged, that's okay.
But we'll dismiss. You find out?
Obliged, I will find out.
Just wait. Heard Mr. Esmo, learned counsel for the petitioner. On 30th/05/2024, this court has granted the petitioners 2 weeks so as to enable him to enable the petitioners to address the court as to whether repetitive writ petitions are permissible when no steps were taken for enforcement of the order passed in the earlier round of writ proceedings. Today, Mr. Esmo, learned counsel for the petitioners, after arguing the matter for some time, pressed for listing the matter on 38/07/2024 to place the judgment which, according to him, is in his favor. The judgment passed by the Noble Supreme Court.
We'll see, my lord. Maybe even High Court also, my lord.
Supreme Court as well as Mr. It is made clear that if no judgment is placed before this court will pass an appropriate order imposing cost.
Obliged.
Your Honor, I'm sorry. There was an order
Yes,
for listing of the matter, 26 item as first item,
yes,
because there was a personal appearance.
yes.
So my officers have come, they are in the canteen. So after this matter,
Let them enjoy the catching.
because they are public
Is it
employee.
contempt?
Yes, contempt.
Is it a contempt?
Is it contempt?
Contempt?
Yes. Public,
Contempt proceedings?
no.
There is
Yes.
a notice for taking a
Appearance.
full motor contempt matter.
Okay. And not yet been initiated.
Not
No.
Okay,
After this item.
okay. Item?
For opening a case, there is typical error detected in this application, this petition in cost title. Respondent number 4, private respondent number 4 name is erroneously written Nani Mali.
There is a private respondent, otherwise we could have disposed of this matter.
Yes, Your Lordship. I'm before here, this one court, only on sole
There
ground.
is a mistake also. This is Nabab Mali.
Yes, Your Lord.
Why you have written Nani Mali?
That was typically error, Your Lord.
You correct it first. And then I'll show you what does this word mean. Page 11. Paragraph 10.
Yes, Your Lord.
Paragraph 10.
Yes, Your Lordship.
Yes, read it.
This petitioner most respectfully beg to state that after submission of representation, he may not be awaiting for outcome
What
of
does it mean?
his, your lordship, it's a human efforts. It's a human efforts. It's my effort to my
See.
representation.
I understand. You may be very good in vocabulary, but certain words you just cannot use like that. I mean, if possible,
Your lordship, I'm
let the
learning.
petitions be simple and precise.
My, your lordship. Your lordship, I'm learner.
These are not
Yes, sir.
to be used. And there's another, page 5. Absorbedly on the same day, page 5.
Your lordship, I mean to say that
Don't use all.
instantly. Yes,
I understand it's good.
yes, yes.
We get to know the words also, but then it's not appropriate.
Yes,
You use
lordship.
the appropriate word.
Yes, lordship.
As far as possible, simple.
Your lordship.
You correct it. Respond number 4. Name of
Yes,
the
sir.
respond number 4. You filed an amended course title.
I mean, good.
Have you realized?
Yes, your lordship.
Have you realized?
Yes, sure.
It's Nabam Mali. It's
Nabam Mali.
Nabam Mali.
It's a typical hero, your lordship.
Or Mr.
Titukur. Tabantukur.
London Council for the petitioner. By filing this application, the petitioner has sought for a direction to the state authorities to take up the complaint case by complaint case number DC ICC public 12020 page 14, 10/20/21. Wherein the illegal transfer of the land to the respond number 4 is pending. Since when?
Since your lordship, 5th September 2023.
Issue notice returnable by.
Your lordship,
2 weeks.
instead of issue, I may be allowed to withdraw and file a
Withdraw.
Your lordship. Your lordship, being
Heard Mr. So-and-so, London Council for the petitioner. Press for withdrawal of the writ petition in view of the mistakes in the defects in the petition. Mr. President, allow this the petition is disposal. Close on withdrawal with the liberty to press.
which one?
Wait, Major.
Yes.
Just before, my lord, may kindly have page 74 of the writ petition first.
Yes.
Relevant portion starts from page 79.
Yes, I've seen it.
There was an undertaking, my lord, your lordship
Yes.
has seen it. So in view of this, my lord, if your lordship peruses the order dated 22/5/2024.
Yes.
So that is how, my lord, since they have not complied, my lord, this, they have asked for, this honorable court has asked for personal appearance. Even after this undertaking, my lord, the benefit of that order was not given.
Yes.
That is how the personal appearance.
Therefore, you file a press petition.
Yes. But since this order, my lord, 27/4/2016 was not complied,
Hmm.
resulting in the filing of the instant writ petition, my lord, present writ petition. This honorable court was of the view that this order 27/4/2016 was required to be complied. That is why this order dated 22/5/2024 was issued.
But then why you have not, if you had not complied with, it was supposed to be complied within 3 months.
Yes, but there was
You
subsequent
have not,
decision,
uh,
there has been a,
remedy.
there is a
Why-
fresh,
why
no,
second
my
writ
lord,
petition?
because there is a fresh cause of action.
What fresh cause of it? Since this has been not complied with,
Because there was a decision taken, but that was not in consonance with the undertaking given before this honorable court.
where it is order,
That is from page 86 onwards.
86.
Yes. This is the benefit that they have given. This is not in consonance with, my lord, what they had undertaken, my lord. The order of the dated 12/1/2016. That is at page 73. There's a fresh cause of action now. We prayed that, my lord, since there was an undertaking and there's a fresh cause of action, that this order at page 73 has to be complied, but this honorable court was of the view that since this order has not been complied with, notice for suo motu contempt was issued. That is honorable court's own instance, man.
They have considered your case,
Yes.
but not in terms of the assurance
Yes.
given by them. It is not in accordance with the order dated
1/2016, yes.
12/2016.
Yes.
So,
We came because there was a fresh cause of action. But this honorable court on its own was of the view. That is how these orders came to pass. We were before your lordship seeking a prayer, my lord. But this honorable court was of the view that
yes, you have agreed,
Lordship,
you made a
Up-
statement in the court, and then now you are saying, I mean, the board is saying that the matter is sub judice.
after that order, first order, there was a contempt petition. In contempt petition, we have filed the documents which we sought to be compliance. That was considered by this honorable court. Then after that, again, this writ petition has come. Now, on that writ petition, we have filed affidavit, of course, short affidavit. Now, this personal appearance has been called for. That is the case. Now, to us, earlier order was also wrong. This order is also wrong. Another, some datas, after all, this is financial matters. Financial matters cannot be this way or that way. It has to be correct. And more so, NERIS is not the only authority to pass any final order in the matter of.
You will see at page 70, it's your stand only, page 80, sorry.
Yes. Yes, yes.
By you only.
No, this was complied. This was complied, but there was anomalies in we are not saying that we will not
No,
pay.
this court has seen that, noticed that this has not been complied.
yes.
Yes.
Therefore, the last three occasions, there are order of this court. And finally, even after allowing a chance, you have said that since the matter is sub judice, you are waiting for the final judgment.
Yes. This was
That's the reason your register has
this-
been called.
this was placed before the bomb and last month, not this month only. This
30th June
30th June,
and 11 June.
11 June. Now the board Board of Management,
Various authorities has apparently not understood the orders passed by this honorable court. This court is clear. They have not challenged it, my lord. Even if the honorable court's order was incorrect,
No,
they
we-
put it to challenge.
we are not challenging it because apparently we are, everybody is beneficiaries of this order. Not only the 7 of them. There are 48 there, something like that are also there. 41 others are there. Now, only because of the calculation, it's taking time. And this calculation, NERIS cannot do so much of its own because it has to be passed by the Board of Management. Now, Board of Management consists of all northeastern states, 2 Human Resource Development Delhi, including Finance Department Delhi. So now, whatever order is to be is passed, that will be forwarded to Delhi for final
No,
implementation.
sir, you have clearly made it page 79. Let us read this. Sir, proceed page 79.
79.
Kindly read it, page 79.
This, no, this we accept. This we accept. But after this, there were,
According to you, you have complied with this.
yes, yes.
Have you implemented this?
No, not in detail.
That's what I'm saying. It is submitted by learned senior counsel to NERIS that the said decision has not yet been implemented in the case of the petitioners due to pendency of the writ proceeding.
Yes,
That writ proceedings.
yes.
Mr. Upon so and so for NERIS submits the writ petition may be disposed of with the direction that the aforesaid decision will also be implemented in case of writ petitioner.
Yes.
You implemented, simple as that.
Implementation in the sense, there is any anomalies in the calculation. Only anomalies in the calculation. It's question of calculation only. Not the
Whatever
entire
you,
scheme.
whatever you want to calculate or no calculation, you implement that, that's all. We're not
As-
going into the nitty-gritty. What is this 12/6/01/2016 is all about? You said you will implement this decision. You will not say that you will consider and send it to the ministry. You said you will implement it. Whatever may be the thing, you implement it, that's all. And now, last, that's the reason again, he was been, the registry is directed to be present in person because despite orders of this court, I mean, twice or thrice. in the
4
last
orders.
3 occasions.
3 orders.
You say, they simply said, this matter is pending, listed for hearing on 19. Final judgment will be sent to the ministry, so casual.
Your Honor, here,
In fact,
Forget about this contempt,
after
this order. The
after
last 2 orders of this court, you are again
violating.
casually
after
responding it.
after this order, said 27/4/2016. It was, if we go by records, it was withdrawn again. Again, it was put back that way, and from administrative side. If we come chronologically, that you can explain it. So that's why, since we have found anomalies and there were complaints and counter complaints, so many things were there. So as an employer, that is all the grievances is to be seen.
You see whatever you want to see, but the order of the court has to be.
No,
has some-
Today, Your Worship, we pray that detailed affidavit, we may be allowed to file detailed affidavit as to how, what orders are coming from Union of India and how NERIS is implementing, and in respect of these 7 petitioners that way. Detailed affidavit, we may be allowed to file the detailed affidavit.
Then in that case, we'll issue a notice for contempt.
My lord, see, after the 18-7 order, that has also not been put to challenge. How can they make a prayer for filing an affidavit now? In fact, this honorable court, because the prayer was made that this board was sitting on a particular date, even after that submission, my lord, the 18-7 order came to be passed, saying that even if the board sits, they cannot go beyond this decision at 12/1/2016. This is the order of this court. How can they go beyond it now? And how can they file an affidavit justifying anything?
Here, Yeah, you,
What is the difficulty in implementing 12/1/2016?
there's anomalies in calculation. So if
That
Union
has
of
been
India,
done.
yes, there is.
They have considered and they have not implemented this decision.
No,
They have a different decision.
yes,
That's why you are
Yes.
checking it.
yes, exactly.
Only figures, figure and the year of applicability. Because this is.
If your lordship kindly page 73, that is the decision. 12/1,
73.
yes.
12(1) also, now we are finding some anomalies in that.
The chairman board of management has kindly accorded approval for re-implementation of office order dated such and such regarding upgradation of faculty members for placement under CAS from the eligible date of individual basis and sanction of financial benefits as applicable to them prior to such and such and granting notional for all future permanent placement with normal increment due for July such and such. Any financial benefits of faculty members who have gone to such and such will be finalized on final court judgment. The area, if any, will be released only when sufficient fund on approach such and such. The issue is from the date of eligibility.
Yes.
That is the issue. And my lord, after this order was passed, the earlier petition came to be taken up. They gave this assurance. That is how the order came to be passed. Now, after seeing that, this honorable court has now passed subsequent orders. Where is the question of man? It's either contempt or they implement this matter.
Yes, you implement. Nothing. You have not challenged the last order, this order, page 79. And in fact, it's
The
on your
direct-
own,
direct-
maybe on instruction you have submitted this, you implement this.
Your lordship may.
This is the only way out. Nothing else.
Register.
Sir,
They have absolutely not understood this honorable court's orders, man.
Sir, the actual problem of this 12 January 2016 order is that in this order, it is clearly mentioned that individually, one by one and individually matter is to be examined. Accordingly, the institute has examined the matter individually one by one. While calculating the pay fixation, some anomalies come up. So because of that anomalies, we have again placed it to the Board of Management for their guidance. And meanwhile, on 30/5/2024, the court has given direction that the matter may be listed on 19/6/2019, 2024. Our meeting, Board of Management meeting was on 11th June. So after going through the detail of the matter, the board has resolved that since the matter is under sub judice, so let the court take the decision, and after that, the final judgment may send it to the ministry for their further guidance and action. That was the resolution.
In that
Sir.
case, my lord, they implement this 12/1/2016 order.
See,
If they are waiting for
then
this honorable
after
court's order.
18/7 order was passed up to that. Fixing the date on 19/6. Then again was listed on 18/7. Then again listed on
23.
Directive 23/7. And on 23, you have placed this decision of the board. Then the court has taken note of that and there is on 23/7.
Actually, sir, as per our.
Implement it.
Yes,
Sir.
it appears, my lord, they are waiting for a direction from your lordships, my lord. I am not after their punishment, my lord.
But the reason is, have you seen this order of this court last occasion, 27/4/2016?
Yes, sir.
And after the,
After the submission of you, I mean, there is the learned senior counsel that you will implement this decision. And then thereafter also court has given that. It is however made clear that the decision reflected in the order dated 12/01/20 would be implemented in case of the writ petitioners as early as possible, preferably within a period of 3 months from the date of receipt of certificate copy. You know way out. Because you have not challenged this.
Yes. 35 order also, my lord.
Sir, how to
They
work
cannot.
out the anomalies? Because there are anomalies. Even if we are supposed to
You are
implement
not
this
going to
order.
Challenge this. We'll go by the court's order. It's too late to review. We cannot review it also. There is no ground for review.
Sir, is it
It's
possible?
basically like a consent order. You want to implement your own decision.
Right, sir.
Court has said, yes, you implement it.
Sir, is it possible
And
to,
then not only on your.
for detailed
then-
affidavit,
Yes.
for the filing of the detailed affidavit?
No, if we allow you to file affidavit, we'll have to initiate. So let us not go into all these things. The way out would be, of course, either this court will, in a strict sense, will go by the orders of this court. But considering the thing that there is some anomalies and all, we'll just say that you will implement this.
Sir, after all, it is going to be a financial implication
Other
matter.
matter.
How it,
See, you
if-
have taken a decision.
even if
You have
we are to
taken a
implement,
decision. And you, in the court, you have made a statement that you need to going to implement it.
right, sir.
You implement it, that's right. Nothing
Sir, we have to seek, we have to send it to the ministry for their funding.
Whatever you
So
want to do
whatever.
it, do it.
Yes, sir.
Whatever you want to do it.
But
that's
for
it.
that,
But we want the implementation of this order, that's all.
For that, again, sir, ministry concurrence is required.
It's, why you take it on your.
My lord, this is what I have been submitting.
What-
The Danish authorities have totally not understood the orders of
Sir,
this
this
court.
is too late in the day to say all this thing.
Whatever
It's
control is required to be
2016
taken, they will
matter.
take.
We'll forward it to the ministry.
No, we'll not say, we'll go by the order of this court. Not only this 2016, the basis is this, and then thereafter series of orders, and then the court has, in fact, shown its displeasure. The last three orders.
Yes, exactly, my lord. After the 35 order, nothing remains, man. That has not been put to challenge.
Heard Mr. Deepang learned counsel to the petitioners.
My lord, the draftings is not very happily drafted. If your lordship kindly at page 63, this is what we are fighting for, man.
Yes.
Two, my lord.
Hmm.
For those faculty members who have fulfilled and prescribed criteria for promotion under CS prior to such and such and are promoted under the scheme at a later date due to delayed operation of CS, the financial benefit will be granted from the date of eligibility in such case. This is what we are seeking.
You want this?
Yes. And that is what is the decision at 12/1/2016, page 73.
70? Yes. Finally, this decision is.
Yes.
taken.
The decision was taken after we filed the writ petition. Earlier writ petition.
They are petitioners, sir.
There are 7 petitioners here, my lord.
They
They all qualify, my lord, in terms of this.
They are professors,
Yes, my lord.
all of them.
Yes, ma'am.
No, sir,
All may not be, my
not
lord. Just
all of them are
Just a moment.
professor.
I will just
Some
put
of
down.
them are assistant professor and some of them are associate professor.
Page 2, my lord.
Okay.
One is professor.
By filing this writ petition, the petitioners, there's 17 members, who are working as professor, associate professor,
Associate professor.
and assistant professor.
Sir, assistant professor,
Professor, assistant professor,
sir,
And
entry grade is assistant professor, then associate professor, then professor.
Yeah, make assistant professor.
professor will say professor.
Associate professor.
comma,
All are assistant professors.
Huh?
Professor and associate professors. at present.
We'll say. Serving in the Northeastern Regional Institute of Science and Technology. In Beckett. In so, in nearest, huh? Pray for the direction to the respondent authorities to implement the order dated 09/05/2015 for upgradation of financial benefits issued by the management benefits but is that page?
Which one, my
63?
lord? 63, my lord.
Implementation of the order dated 19/4/2005. Whereby it is provided that for those faculty members who having fulfilled the prescribed criteria for promotion under CAS prior to 01/07/2004 and are promoted under the scheme at the later date due to delayed promotion of CAS capital, the financial benefit would be granted from the date of eligibility in each case. The petitioners have no
Page 7,
filed the
74.
writ petition being WPC 91 FE 2014. Praying for the same, praying for implementation of the above order list of the writ petition was disposed of by this court on 27/04/2016, which are reproduced herein below, page 79, from third para of the court is. On they are reading of the above order passed by this court. But it transferred that the nearest authority has clearly placed has clearly that the decision has been taken on 12/01/2016. However, same was not been implemented in case of the petitioner due to pendency of the earlier the writ petition within bracket clause. The Lord Standing Council for the nearest has submitted that the writ petition be disposed of with the direction for implementation of the decision dated 12/01/2016.
16.
As the authority would implement the said order in case of the writ petitions. It was only apprehended that the since the notification does not lay down any definite time frame for implementation of the scheme of the order. A direction was sought from this court for fixing a time frame in the matter. Having considered the submission, this court had made it clear that the decision reflected in the order dated 12/01/2016 be implemented in case of the writ petition as early as possible, preferably within a period of 3 months from the date of receipt of the certificate of the order. Next. It is stated at the bar that the order dated 27/04/2016 has not been put to challenge by the authority. And in fact, it would not have been, as the order has been passed on the submissions and admission of the on the part of the authority, and it is authority. It is further, it is noticed that this court, having considered,
My lord, if I may just point out,
oh,
they took this impugned decisions from page 86 onwards. That was not in consonance with 12/1/2016. They took a subsequent decision after that admission before the honorable court.
yes,
But that was not in consonance with the 12/1/2016 order. That is why we are before this order. That is from page 86.
it is also noticed, it is noticed that the after the opposition above order of this court, the respondent authority has taken a contrary view by issuing the
Office order dated 10/1/27.
office order dated 10/01/2017 to all the petitioners, contrary to the decision taken on that is
12/1/2016,
12/1/20.
page 73.
2016. This being agreed, the present petition has been filed. Next bit. Having taken note of the fact that the despite admission and despite agreed to implement the order dated 12/01/2016. The respondent, having been passed the impugned orders contrary to the said decision and the order of this court. Said decision dated 12/01/2016 and order of this court dated 27/4/2016. Now, this court has taken a serious note of such action on the part of the respondent authority. Accordingly, on several proceedings on different day, has made an observation to place on record the instruction whether the order of this court dated 27/4/2016 had been duly complied with. Thereafter, on the prayer of the Legislative Council for the next finally it was fixed. 23/07/2024. The Legislative Council for the next has placed the communication before this court issued by the registered in charge, dated 22/07/2000, indicating that the compliance of the direction fund was in the earlier round of litigation. On perusal of the said communication, this court expresses its dissatisfaction as the instruction indicates that the Board of Management.
Yes, sir.
Board of Management has taken a decision with regard to the case of the petitioner that has taken a resolution.
Yeah.
That since taken a resolution to the effect that the matter is under sub judice and the Honorable High Court and the listed for hearing on 19/06/2024, and the final judgment of the court will be sent to the Ministry of the Government of India for further guidance and action. Taking note of such casual approach by the respondent authorities, this court has directed the register of the list to appear before this court. Accordingly, the register of the list appeared today. On the pointed query to the senior counsel as well as the register nearest. both have made an attempt to justify their action to the effect that since the matter involves since the method involves the financial implications, the nearest authority has no power to take a final decision. Mr. They have submitted that though the authorities have considered due to certain calculations, the as per procedure and the applicable rules, due to certain calculation, though the decision dated order dated 12/01/2016 has substantially been implemented with, there may be differences to a different officials or officials of the to their entitlement of the institute. Next paragraph. Mr. Deepak, when it concerns for the petition, referring to the impugn orders issued to the petitioners, impugn order passed by the respondent authorities and issued to the, in respect of the petitioners, dated 10/01/2017, has submitted that the order clearly reflects that same had been in total contradiction to the order of the decision dated 12/01/2016 and the assurance given by the respondent authorities for implementation of the said order. So we'll direct you to comply.
Yes.
As per the decision of so and so, taking a lenient view. All right.
I'm
unnecessary.
not,
You
I'm
want-
not after him,
yes,
my lord. This
yes.
honorable court wanted.
Will not be.
Yeah, I'm not after him.
Next paragraph. I've considered the submissions of the learned counsel for the parties as well as perused the materials. Next paragraph. On consideration of the impugn orders as well as the decision oblique a decision oblique order dated 12/01/2016 and the order dated 27/04/2016 passed by this court. It transpired that this transpires, is noted above, the respondent authorities through their council, standing council, standing council, senior advocate, has assured this court in the earlier round of writ proceedings for implementation of the decision of the order dated 12/01/2016 without any reservation hereof. On accepting the submissions, this court has clearly directed the respondent authorities to implement the decisions dated decision as reflected in the order dated 12/01/2016 in case of the writ petitioners within a period of 3 months from the date of receipt of the certified copy. From the date of receipt of the order. List. Next one, there is no dispute. Is reflected from the action as well as the submissions and the documents that the despite such assurance by the legislative council representing the nearest the has failed to implement the decision reflected in order dated 12/01/2016 as assured and directed by this court, as assured by the learned council to the learned study council and directed by this court for implementation as on date. Next one. Should I say that you have assured to implement it?
Sure, yes, we are sure to implement it, subject to if the
it's subject to-
financially,
subject to-
financially, if the ministry is
Fair.
concurrent, given concurrence.
Having faced with such a situation, having faced with the fact that the authorities have failed to implement the decision reflected in order dated 12/01/2006 in its letter and spirit, and has failed to comply with the order of this court dated 27/04/2016 on the assurance given in the earlier writ petitions, the writ proceedings. The registrar as well as the learned senior council have assured to implement the same in the case of petitioner. You have no way out. Another assurance. We'll give you the second chance. All right? Because you cannot retract it. You cannot retract that. It's very clear.
Since I
And
Board of Management also.
we have a hope and trust
That is true.
the responsibility of the learned senior council as the registrar. So because we don't want to go in the other way, which may have a adverse, effect on the parties.
Only in the order, in the last case, you possible file, that any anomalies will be taken care of and on individual basis.
No, you have not reviewed the 2012, the 16 order also.
Yes.
12/01/2016,
Not been
which you
reviewed.
have assured to implement, that has not been reviewed also.
That's the problem. There is
So-
all for them. But
Have-
thing is, Meris is controlled by northeastern states and
Having,
Union of India. That is the problem.
having considered, come on, taking the lenient view, come on. I'm of the considered view that the writ petition can be disposed of by directing the responding authorities, that is Marist, as well as the ministry.
Yes.
Yes, sir. Ministry of
Ministry
Education.
of Education,
Government
Government of
of
India,
They are the final
To-
authority.
implement the decisions as reflected in the order dated 12/01/2016 in case of the writ petitioners by complying the order dated 27/04/2016 passed by this court in WPC 90 on April 2014. the accordingly, it is directed so and so to implement the so and so, implement the decision reflected in order so and so, so and so. Order dated 12/01/2016, within a period of 2 months, 2 months from today. Mr. In the result, the impugn orders dated so and so 10/01/2017 passed by
the registrar.
register nearest in respect of all
The
the
petitioners.
petitioners are hereby interpreted within set aside. It is next para. It is made clear that the instant order has been arrived and on its own peculiar facts of the matter, and same shall not be treated as a precedent in any other proceedings. With petition mistakes.
Problem. Impugn order dated 10/1/2017.
Then the personal appearance, just wait, just wait. When I have said that the register so and so directed to appear in person so and so, in that you right, accordingly, Mr. Kamdir, MK Kamdir.
Yes, Dr.
Register, Dr. MK Kamdir, register so and so, is present today. No, that's one. Then last, the presence of the appearance of Mr. Dr. MK Kamdir, registered nurse, is dispensed with.
Thank you.
Seven, my lord, the additional affidavit we are filing today, ma'am.
Seven.
Yes. Filed during the course of the day. The lordship has granted permission on the last.
This is for what? Case is about?
About, my lord, the punishment imposed, my lord. My lord, in the police rules, there is a provision that if the income delinquent is, my lord, acquitted in a criminal case, then no proceedings can be done.
The appellate authority has modified to 2 years.
It's modified, but we are saying, since
Should be happy.
I think I have a pretty
You have
good
been
case, my lord,
you have
and
been
now
at a-
by bringing the additional document on record,
Recently, I have authored a judgment sitting with the chief, no interference.
now, my lord,
Following the strict,
when the additional affidavit comes, the rule itself provides that once a delinquent is acquitted in a criminal case, then, my lord, there cannot be any subsequent departmental process. That is in the rules itself. That is what I want to bring on record.
Mr. You have not filed as yet.
We'll file today.
Okay. Mr. Deepang Lalit, counsel for the petitioner, submits that he has filed the additional affidavit.
Yes, we'll be filing this.
Bringing in on record a subsequent development or?
No, the Arunachal Pradesh Police Service rules
Okay.
and the judgment of the district and session judgment. In the
Bringing on certain documents and effects and certain documents for their adjudication of this matter. You have received?
They're in the course of filing.
Then in that case, you said you have not filed as yet.
My lord may say, we'll
Submitted
file
that,
during the course of the day.
He's filing a additional affidavit during the course of the day. So and so, during the course of the day, bringing on record, to bring on record certain facts and
Additional.
reports for fair adjudication of this matter. Considering the above, considering the above, let this matter be listed after 2 weeks.
Right.
2 weeks.
2 weeks.
2 weeks.
Item number 8,
5 minutes, we have to list this matter before any other bench without me.
All right.
The same thing, no?
Yes,
Compensation.
yes. I was about to point out.
Yes. Any other? Why this? Why these matters are rostering around me? What is to be done today?
My lord.
Yes, sir.
Already I have submitted, the synopsis of the substantial question of law. So today it may be formulated, Your Lordship.
Okay. Yes. Madam,
My lord, my item is at item number 10. Let
it's a
them,
cross appeal or what?
yes, lordship,
Both are agreed by the judgment.
yes, but on different grounds.
Yes.
If he has objection, he'll
Yes.
address.
Yes, I have objection, my lord. My lord may heard their point, the substantial question of law, my lord.
Okay. So,
I have objection on it.
do you have an objection? You file an objection.
No, my lord.
You'll make your submission orally without filing objection.
My lord, let them, my lord, pass submit, make submission on their formulated, my lord, this substantial question of law, my lord. How this can be a issue in this second April, my lord. Now, example, my lord, I am saying the issue, my lord, issue number 1. As per them, my lord, there is a issue involved regarding ownership based on interpretation document considered substantial question of law, my lord. Now, if we go by the impugned judgment, my lord,
Where is your substantial draft
Yes.
issue? Substantial question of law?
Now,
Where it is?
huh?
Roman number 2, page number. Page number, Roman 2.
Of appeal.
Page number
RSA.
2. Page number
What is this? What is IFO? What is IFO?
Page marker, I have given page marker.
This is IFO what?
Oh, regarding the
Interlocutory
Your Lordship,
application for what?
There is one I.
Yes, I'm asking what is, this is for what?
Regarding this Your Lordship, pending this, the respondents, what they
Yes.
have done, so they with some labor and bulldozer, etc., they enter into the suit land. They wanted to take possession. So that may be prevented. Only that is my prayer.
Yes, page.
Substantial question of law. The main question is that the land was allotted by the government to the industry department in the year 1980. But suit was filed in 2016. Apparently, it is barred by limitation. And regarding that, the lower court dismissed their suit, but appellate court reversed it. So this reversal is substantial question of law because without going through the record, that was reversed. Number one, I have given your original court held paper exhibit one cannot confer any right, title, interest on any immovable property to the plaintiff. However, learned appellate court held to the contrary. Now this paper exhibit one is a letter where paper exhibit one certificate given by their relative, Vice President Moyong, the Onchol Committee, not specifying any area or description of the land. That paper exhibit one.
Yes, sir.
So that is paper exhibit one. The finding of the lower court was that paper exhibit one cannot confer any right, title, interest over the plaintiff. But that was reversed by the appellate court without going through it. So that is substantial question. Then construction of documents. Certain documents were exhibited. Exhibit 1, 2, 3, and 19. One certificate given by Vice President, not specifying any area, nothing. And whatever is given in the certificate, that land was sold by Mr. Moyong earlier. And now second letter dated 4/2/97. They're claiming certain compensation. And regarding that, your lordship, nothing was given like regarding the DL, disputed land. Then what happened after that? One notice was sent to advocate. That notice is exhibit 19. In that notice, certain land was claimed. That land is different from the suit land. So identification of suit land is very important. And that was not identified. And that was held by the lower court. An appellate court reversed it. So your lordship, the thing is that apart from that, the burden of proof always lies on the person who claims certain thing, which is in the possession of other person. And the person who is not in possession, he has to show everything. So burden lies on him, but he did not shift the burden or discharge the burden. But the appellate court says that no, burden is discharged, no. So that is the burden of proof is a substantial question of law. A very important point is that the land was allotted, that is record will show, on 12/1980 for industry, that is citronella industry. But this suit was filed in 2016, after 36 years. Apparently 12 years disposition, limitation act says that if dispossessed within 12 years, they have to file. After 36 years, it does not lie. So this is something like sleeping like a Rip Van Winkle, your lordship. So this suit involves certain substantial question of law. And now at this stage, your lordship, I refer to the Guwahati High Court rules, 5/6, page 387. Even at the stage of admission, the question of law, brief synopsis, written submission, each proposition should be filed so as to enable the court to consider whether there is substantial question of law. Wherever the court is inclined to entertain the appeal, apart from the normal procedure for service as rules, advance notice shall be given. That is there, Your Honor. Now, at this stage, substantial question of law is to formulate by the Honorable Court. That is even Honorable Supreme Court also held like that. It will be error if it is not formulated by the Honorable Court. Draft is given by me, by the appellant. At this stage, then opportunities to be given to the respondent to reply over those substantial question of law.
So according to you, you have 1, 2, 3, 4, 5, 6. 6. May I read your lordship this? Ranjan versus Honorable Not necessary. May I read this? Not necessary. This is the, I think, formulation. Whether your draft given by you is it can be formulated, that is, we'll see. Yes.
Now, my lord will kindly appreciate, my lord, in second appeal, my lord, it's not only question of law, my lord. It should be substantial question of law. Now, I have received a copy, my lord, where, as much as they have prepared 6 substantial question of law. If my lord look into past substantial question of law, my lord.
Yes.
Now, here, the issue involving regarding the ownership based on interpretation document constitutes substantial question of law. My lord. Now, that can, my lord, this get until and my lord, this, my lord, pertaining issue, my lord, should be connected with the impugn judgment, my lord. What is the perversity, my lord, while interpreting? Now, that is not there, my lord. How that can be substantial question of law, my lord? If now, if we go by the judgment, my lord, not only this, my lord, interpretation document is not only the basis of degree pass in my pair, my lord. In addition to that, my lord, there is a oral evidence, my lord. Now, I say, my lord, this is one, my lord, cannot be substantial question of law, my lord. Until another, that is connected with the perversity in the judgment, my lord.
Yes.
2, my lord, construction of documents under which the claim of property is made at my lord. Same, my lord. Simple construction of documents under which the claim of property is made a substantial is substantial. That cannot be, my lord. Always, my lord, if I claim title, my lord, I either it be in the base of documents or some evidence, my lord. How that can be, my lord? My lord, I'm again repeating, my lord. It in second appeal, it not only question of law, my lord, it should be, my lord, substantial question of law, my lord. Now, 2, my lord, also does not, my lord, come under purview of the substantial question of law, my lord. Perversity in finding in the question of law, my lord. Now here, my lord, the explanation they has given, my lord. The finding of learned appellate court that the preponderance of probability and balance of convenience in favor of the plaintiff, my lord. Now, this is the law, my lord. If in a civil, any civil case, my lord, the proof, my lord, the proof cannot be beyond reasonable doubt, my lord. The proof can be always by in preponderance of probability, my lord. Now, where from this, my lord, the substantial question of law arises in this issue, my lord? And they said that in plaintiff, that is under the position of father of plaintiff, but the dependent wife 6 has illegally occupied the said land and thereby disposed the said land without proper following the due process, which is not based on the record, therefore purpose in December. This is all based on the fake, my lord. Whole this issue, my lord, is based on the fake. Now, 4, my lord, non-consideration of the evidence and material fake produced by the party is the substantial question of law, my lord. At the most, that can be, my lord, but for that, my lord, now what explanation they have given, my lord? They have given, my lord, plaintiff and defendant exhibit several documents. In the documents pertaining to ownership of the suit, compensation paid to the beneficiary against the suit land are not considered by learned appellate, my lord. That is not true, my lord. If we go by the, my lord, look into the impugn judgment, my lord, judgment, my lord, that has been looked into, my lord. The whole the aspect, my lord. The learned appellate court unduly rely upon the schedule of the plan, which in the peg allotted, owned and possessed by the appellant, responding number and dependent of 3 since 1981, and is still being used for cultivation. Citronala established factory, labor quarter, there on whereas land of respondent number 1 to plaintiff number 1 is given in their statutory notice that, my lord. Now, hold this, my lord, is the whether it is statutory notice, my lord. Beyond that, my lord, whole issue, my lord, discussed in the judgment, my lord. I can pinpoint it, my lord, in the impugn judgment, my lord. Now, this all is based on the fake, my lord. Now, if that is based on the fake, my lord, that will not come under substantial question of law, my lord. The apex or repeatedly, my lord, define what is the substantial question of law, my lord, for the second appeal. Now, 5, my lord, whether suit is Been by limitation is a substantive
Barred by
question.
limitation.
Bar by limitation. Now that also has been, my lord, bar by limitation, my lord. That has been discussed in the judgment, my lord, and then, by relying some aspects of judgment that we given, my lord. The judgment has been passed, my lord. Now, for that, my lord, if they bring this issue into the substantive question of law, my lord, they need to pinpoint, my lord, what is the perversity in the exact reasoning of this appellate court, my lord. Now they need to pinpoint it, my lord.
The appellate court below has, what is the decision on this? Limitation?
No, limitation.
What is the findings?
They say if my
What is the findings on limitation?
64. Article 64 involved, not 65. Article. Now, my lord, I beg to submit subsection 4 of section 100 CPC. And it is clearly written that appeal shall be heard on the question so formulated. And respondent shall at the hearing allowed to argue, not now. First, your honor has to formulate the substantial question of law.
But we'll have to see
that
whether
will be in the
your
appeal.
challenge, is there
And
any
the
substantial
synopsis in the
question
synopsis
involved or
also.
not?
No, your lordship has to, now that is the observation made in Thangarajan versus Venugopal. Honorable Supreme Court 2004.
On what? Limitation? On limitation? What does it say?
So at least 16. At least later then there will be error. First, honorable court has to formulate on the basis of memorandum of appeal. And on the
Look,
basis
you're submitting a draft. Your appeal has to, second appeal has to involve a substantial question of law. That is which you have tried to frame. I mean, submit the draft. This is with regard to formulation of substantial question of law, other than the formulation at the stage of admission, whether at the time of hearing it can be formulated or not.
This particular law point, my lord, a limitation has been answered in page number 43, my lord, by the learned appellate court, my lord.
Page 43.
43 of the appeal, my lord. The issue, page number 42, my lord, we have first look, my lord, 42, my lord. Second part, finding of this court on issue number 3. It is admitted position of the fact of the case that the brother of plaintiff was disposed in 1980 on the establishment of citronal industry at disputed area. However, the learned court below has not addressed the point raised in written argument by the appellant. The plea of appellant is that the government cannot take plea of limitation to the citizen and rely upon the judgment of honorable court, Supreme Court in case of such and such as well. Therefore, reason at para 31, having gone through the refer A of judgment, it is clear that in order to make a claim of limitation under 64 under principle of adverse possession, the dependent is required to admit the fact that the plaintiff is the true owner of the suit land to make claim under principle of adverse possession or continuous possession. But in present case, the dependent has denied the title of plaintiff, but they stood to have been acquired the land from the respondent was 6 to 8. Hence, the plea of dependent over 5 to 5 on continuous possession is erroneous. Therefore, the finding of law court below is purpose in law. Further, the judgment above in 1B clearly showed a light, throw a light that the state government or public undertaking or government department or police being a protector under principal welfare state cannot be allowed to be property grabber. The para 45 of the judgment is very clear who is quoted here under. If the property of the protector of the land become the grabber of the property, land and building, then people will be left with no protection and there will be a total anarchy in the inter-country. It is indeed a very disturbing and dangerous trend. In our concept view, it must be established with a further loss of time in larger public interest. No government department, public undertaking, and much less the public police department should be permitted to protect the title of land or by building by evolving the provision of adverse possession and grave the property of the sponsor in the manner that has been done in this case. Therefore, my humble submission, the issue number 5, my lord, at the most, it can be a question of law, my lord, not the substantive question of law, my lord. Now, that question of law has been answered by the appellate court, my lord. 6, my lord, they are saying to whom proof of burden lies. It's a substantive. Now, that cannot be, my lord. The burden, the proof of burden lies, my lord, that is well settled, established, my lord. Burden always lie to the plaintiff, my lord. In the civil case, my lord, that is preponderance of probability, my lord. Now, that has been answered, my lord. Until and until, my lord, they pinpoint, my lord, some perversity, my lord, on the fake connect with the question of law, my lord. That cannot be substantive question of law, my lord. Therefore, my lord, my humble understanding, my lord, at the
There is
judgment,
no substantial question of law.
there is no substantive question of law, my lord, to decide by this law report, my lord. My lord will have a look at the judgment, my lord, impugn judgment, my lord, and look involve this issue, my lord. I believe, my lord, there is no substantial question of law involved in this case, my lord.
So, by reading this, the issue of limitation, barred by limitation, in view of the fact that the state cannot take the ground of adverse position,
My lord.
Verify.
the limitation would not be barred.
Section. This Article
Is not it?
65
My lord.
that is wrongly inserted. It is Article 64. Because
Sir, that's the reason this matter has been fixed again and again.
because of the
Don't
fact
force
that-
me to let this matter.
because law
adjourn.
enforcement title is not recognized in.
Sir, you are not able to support this,
Now,
assist this
64,
court
65 is
since
con-
last
concerning title.
previous
64
many
is
occasions.
position.
Are you getting me? You are not able to assist this court for the last many occasions. As in when this matter is taken up.
তো ঠিক আছে কি হলো So regarding para 5, your lordship,
Yes, what do you say on this?
My humble submission, my lord, there
Just
is,
because the state cannot have taken the point of adverse possession
my lord,
against the citizen.
my lord.
because of Article 300A. Can we say that the limitation is not applicable? And there's no limitation is not barred.
My lord, for that way, my lord, this
That could be a.
that has been insert in two poles, my lord, but appellate court, my lord. That their plea, my lord. In their written statement, they never recognized my title, my lord. What their plea, my lord, pleaded case was, I am not the owner, my lord. Until and unless I am not the owner, my lord, they cannot go for the adverse person. That's why, my lord, I say, my lord, have look in that has been, I say, beautifully answered by the appellate court, my lord. There is then say, my lord, I am not the owner, my lord. Owner is this other appellant in this other case, my lord.
I can provide position.
So according to you, there is no substantial question of law.
No, my lord, there's not alone, my lord. The burden of proof, my lord, that is cannot the issue number 6, my lord. They say the burden of proof, where the burden of proof lie, my lord, is substantial question of law, my lord. I say that it's not question of law, also, my lord. That is well settled, my lord. The burden proof by always to the plaintiff, my lord. Now, pipe, my lord. For pipe, yes, my lord. Somehow, where I agree, my lord, that can be a question of law, my lord. To make that a substantial question of law, my lord, that they, my lord, need to pinpoint what is the perversity in the judgment, my lord. Until in that is connect, my lord, that cannot come under the substantial question of law, my lord. That is only a question of law, my lord, and question of law cannot be a issue before the second appeal, my lord.
Now, why you are saying there is no substantial question of law? I understand he could not make out.
My lord.
Even the draft doesn't disclose anything.
My lord, the issue, my lord.
Simply saying this, there's no, I mean, substantial question of law will not do their objection.
No, my lord, that
That is
substantial.
as simple as denial, as simple as opposing.
Well, if I allow, my lord, they have formulated S+6, my lord, in this case, my lord. Now, issue wise, I say, my lord, first issue, the issue involving regarding ownership based on interpretation of the.
We can frame on the issue interpretation. Yes.
My case is slightly different,
Hmm.
Lordship, but I will first submit on the substantial question of law.
Yes.
Your Lordship, I would like to rely on 2008 volume 8 SCC 92, para 13.
Yes.
Where there is a clear enunciation of law and the lower court has followed it or rightly applied as a constitutional question of law. But if there is a clear enunciation of law by this court or in high court, that is in para 13 also. Middle portion, answering what is substantial question of law. That would be at page 103. Just in the middle portion, where there is a clear enunciation of law and the lower court. Page 103, 2008 volume 8 SCC 92. I'm reading from the middle portion. In para 13 starts with what is substantial question of law. From the middle portion, where there is a clear enunciation of law and the lower court has followed or rightly applied such clear enunciation of law, obviously the case will not be considered as giving rise to substantial question of law, even if the question of law may be one of general importance. On the other hand, if there is a clear enunciation of law by this court or by the high court concerned, but the lower court had ignored or misinterpreted or misapplied the same correct application of law as declared or enunciated by the court, the high court concerned would have led to a different decision. The appeal would involve a question of substantial question of law between the parties. So basically, this is what a substantial question of law should be. Now, Lordship, in the current situation, I would like to rely on 2007 volume 5 SSC. I'm saying, I'm relying on the earlier judgment just to say that there has been a wrong application of law. Then, Lordship, 2007, Volume 5, SSC 669. In this case, I'm relying on paras 10, 11, 12, 13, 14, and 15. In this case, what happened? The property, suit property, was not adequately identifiable. In the comparison of the sale deed and everything, it was not clear. There was a discrepancy. In regard to that, in para 12, Lordship Messi, there cannot be any doubt whatsoever that a substantial question of law is different from a question of law. Interpretation of a document which goes to the root of the title of a party to the list would indisputably give rise to a question of law. In para 13, in Reverend Father M.S. Paulos versus Vargas, interpretation of the recitals contained in a document was held to be involving a substantial question of law. What is prohibited for the High Court while exercising this jurisdiction under Section 100 CPC is to interfere with the finding of fact. The limited jurisdiction inter alia would become exercisable when the findings are based on misreading of evidence or so perverse that no reasonable person of ordinary prudence would take such a view, the said view. Then, Lordship, para 15. The question recently came up for consideration before this court, albeit in a case under Section 130A of the Customs Act in the Commissioner of Customs Prevention versus Vijay Dashrath Patel, wherein it was held. We are not oblivious to the fact that the High Court's jurisdiction in this behalf is limited. What would be substantial question of law, however, would vary from case to case. Moreover, although a finding of fact can be interfered with when it is perverse, it is also tried that where the courts have ignored the weight of preponderating circumstances and allowed the judgment to be influenced by inconsequential matters, the High Court would be justified in considering the matter and coming to its own independent conclusion. The High Court shall be entitled to opine that a substantial question of law arises for its consideration when material or relevant facts have been ignored and legal principles have not been applied in appreciating the evidence. Arriving at a decision upon taking the consideration of irrelevant facts would give rise to a substantial question of law. Even in a case where evidence is misread, the High Court would have the power to interfere. So in circumstances where there is a misreading of evidence or the findings are so perverse, it would amount to a substantial question of law as per these judgments. Now, Lordship, in this case, what happened? In my case, I was the defendant number 8. In this suit before the civil judge, senior division, their claim was that their land was taken without consent, and in lieu of that land, I, along with two other persons, we were given compensation. Meaning thereby that the land that for which we were given compensation was not our land, and that land was taken over by the Department of Industries. Now, what happened in the suit? The trial court dismissed their suit, saying that even the schedule of land is not identifiable because it is different. Even not just the schedule, even the measurement of the land is different. There's so many documents which I have annexed also. So many documents in which it is so different that it is difficult to say which land is which. Basing on that, the learned trial court has dismissed their title. Now, the learned appellate court ignored all this and simply stated that there is nobody in that place. So therefore, that the land that he divided into plot number 1, 2, 3, and saying that because there is no record of anybody being in plot number 1, so therefore the land belongs to the appellant plaintiff. That is the finding. Then also, Lordship, what happened is before the learned trial court, the proceedings were proceeded ex parte against me without any proof of service. Thereafter, before the appellate court, when they filed the appeal, they again made me a respondent, so I had appeared. I had filed a written objection saying that I may be given opportunity to adduce additional evidence, which was not allowed. In the judgment, in the findings would be at para 30. So regarding this also, the learned trial court has simply said that I have not filed applications to vacate the ex parte decree against me. But what the learned Supreme Court has said in AR 2022, 4213, the learned Supreme Court has said in such circumstances, even if there is an ex parte order against me, suppose, even if I do not file an application under Order 9 Rule 13, then also in an appeal, I have the right to file for to defend the case basing on the merits. It is not that even in a situation where an application under Order 9 Rule 13 is rejected, in such a case also, there is no bar for filing appeal. Now, of course, if the appeal itself is dismissed, then it's a different case. Lordship, may I read AR 2022 SC 4213. 4213. Para 7 and 8.
Seven.
7 and 8. It's a very long one, so Lordship may. We have carefully given consideration to the submissions.
Has it said that the such an issue can be a substantial question of law?
Lordship, the learned trial court has rejected my case, saying that I have not filed any application for ex parte, for setting aside an ex parte proceeding, Lordship. So this is what I'm trying to arrive at is, this is ignoring the settled position of law. When there is a settled position of law, and if the court ignores it, goes against a settled position of law, that would be a substantial question of law. That is what I was saying in the first first judgment that I read, Lordship. That is 2008 volume 8. What 2008 volume 8 says is that if there is a law and the court has followed it, there is no question of any substantial question of law. But if there is a settled position of law and if that has not been followed, then it would amount to substantial question of law. Now, the substantial question of law, which I have framed, which I have suggested, is at page 23 of my petition, basing on these facts. Page 23. That a substantial question of law is whether the Honorable First Appellate Court ought to have framed issues for determining the appellant's case, especially in view of the newly pleaded facts in the appeal. That the substantial question of law is whether the Honorable First Appellate Court erred in law by deciding the first appeal in favor of the respondents 1, 2 in the absence of any evidence and thus without any foundational facts. That the substantial question of law is whether the Honorable First Appellate Court erred in law by not allowing adducing of additional evidence in view of the pleadings made by the appellant, which brought about additional facts and which would have been substantial to decide the case finally. Then the fourth, that the substantial question of law is whether the Honorable First Appellate Court erred in law by summarily rejecting the appellant's case on the ground of his non-participation in the trial court and not challenging the ex parte judgment in the suit, especially in view of the settled law that the defendant has the liberty to challenge a judgment in appeal on merits, even without filing application for setting aside an ex parte order. Then the fifth one is on the question of limitation. Now, Lordship, I'll just
Limitation is also, this decision is based on the ground that since the state cannot take the issue of adverse possession. so
Yes.
Limitation doesn't.
That would be apply in the case of the state. In my case, that would not apply because I am a private person. He's saying that the land,
That's why I'm saying in the first appeal.
yes,
I think that would be the only substantial question as per which they.
Yes.
As
in their case, maybe,
submitted in the draft.
yes.
Others are farmers and all these things, it's although. Even if
The,
there's
the
a
second,
purposely
the second
only
citation
there-
which I have placed, Lordship,
Yes,
in that case also, the property, which the suit property was not adequately identified. Now, your Lordship may see page 6 of my petition. In para 10, I have mentioned the various discrepancies. I have mentioned the various discrepancies to show that the suit land itself was not identifiable. First is, Lordship, in the 10A, Lordship, the Lordship may see the schedule of the land. This is the schedule of the land in the page 6, Lordship.
okay.
Then in the certificate, there is no measurement of land. Then the father of the plaintiff, respondent, had written a letter in 4th February 1997 claiming the land. There, the land is only 593 square feet, whereas they're claiming more than 5,000 square feet. Basing on which they're claiming, so they're basing a claim on the claim made by the father on inheritance, Lordship. Then in the letter dated 29 June 2015, whereby the suit land was claimed, copy of no objection was certificate was submitted. In the NOC, the schedule of the land is again different. Lordship may compare this with 10A. Then in the legal notice also, the measurement and the suit land is different. Sorry, the schedule of the suit land is different. In reply to the legal notice also, it is different. So basing on this, the learned trial court had rejected the claim. Now, could the appellate court have simply ignored?
This first will frame,
Yes,
will formulate,
yes.
and third,
Two, Lordship, I'm saying there is no any foundational facts.
no, this cannot.
The foundational facts, because Lordship, because in the absence of any evidence, could the plaintiff be said to have established anything, Lordship?
I think one, one, 4, and 5. This will not say this will be involved with his case.
Yes.
Yes. I'm of the view that I'll just modify this, whatever is there. Substantially, this 1, 3, one, 4, and 5. Just check it out. Or Mr. Where have you seen this?
Reported a
I may be here.
We'll frame
Now-
for three issues, substantial question. I mean, the formulate these four issues.
No, my lord, the
questions.
present applicant, my lord, is in different voting, my lord, and I need to answer that, my lord. Now, in this case, my lord, the issue raised by this.
Heard, Mr. What is, it's okay.
No, my lord, this is.
I am at learned counsel, respondent number 4, learned counsel. In RSA number, what is that? Just give the number. And also heard MS.
My lord, framing the issue in both case, my lord. Now, therefore, my lord, I may be, my lord, because, my lord, that's why, my lord, the same argument I was expecting from the other side, my lord. Now, here is, my lord, this.
I agree to all other cases, other draft issues by him, that only one I am framing in his case regarding limitation.
No, my lord. In
Alright.
my lord.
Rest I have accepted your argument.
That's okay, my lord.
And in the second case, I'm formulating the 1, 4, and 5.
No, my lord, that's why. Way, my
In
lord.
view of the judgment of the Supreme Court.
No, my lord, that just, I'll clarify. That
Because
judgment.
reason being, the appellate court below has said the learned trial court has gone against the decision of the
No, my lord.
Supreme Court.
That judgment does not say. If I correctly understand, this judgment say, my lord.
We'll
Yes,
see,
my
we'll see.
my lord will no, my lord will look in.
And Mr.
My-
L. Learned counsel for
No,
the
my lord
response.
will only hear one came. I will
After hearing
explain
the
this judgment only, my
After
lord.
hearing the learned counsel for the parties, the following substantial questions are framed here in the below.
My lord will let me clarify on this aspect of judgment only, my lord. That judgment, my lord, applicable, my lord, when, my lord, the party against whom X party degree, my lord, is passed, that make appeal, my lord. Here is a case, my lord,
Are being
the,
framed here in-
this, my lord, appellant, my
I'll
lord.
see you.
Though
Well,
X party,
I'm framing, I mean, I'm framing, I'm formulating 4 substantial question of law, that's all. I mean, 3.
no, my lord, that way, my lord,
1, 4 in the, you say, 1, 4, and 5. 5 include his,
no, my lord, in his case, that cannot be
Well,
even
consider,
in
admit.
question of law, my lord.
list for hearing after 4 weeks.
My lord, in my objection, my lord, in her case, my lord, this cannot be even question of law, my lord. Why? Because, my lord,
Well,
the judgment by the trial court, he did not make any appeal, my lord. It was in my appeal, he appeared, my lord. He appeared, my lord. Now, therefore, this judgment, my lord, will be applicable when my party without availing the.
Okay, I'll see. Prime facie, I'm framing 4 issues, 3 issues only. Three substantial question of law. That's all.
But this judgment, my lord, this judgment had been wrongly placed, my lord. This is not applicable to her, my lord,
see,
because,
see.
my lord, this is the judgment applicable when a party against whom X party judgment is
So
passed.
according to
appeal.
you, are you saying that the appeal, forget about the draft
My lord,
substantial question of law?
my lord.
Do you, according to you, the challenge or the appeal order
My lord.
of the appellate court below, there's no substantial question of law involved. Are you saying so?
My lord, in his case, yes, my lord, because he is not aggrieved by that judgment of trial court, my lord. He did not make any appeal, my lord. Now, in my appeal, my lord, he appeared, my lord. He played for additional the evidence, my lord. Now, about the question of additional, the CPC is very clear, my lord. When that can be allowed, my lord.
Additional, that's why this.
That was not
see,
allowed.
No, see the draft, her draft one. That's why I'm not formulating that one, second one.
No, my lord. That's why,
Second, I am not formulating.
that's why, my lord. That's why, my lord. The judge, my lord will frame only a substantial question of law, my lord.
Yes.
Here is a case, my lord. The answer is that question of law, my lord, has been answered in the
That
CPC, my
second,
lord.
I am not
So
formulating.
there cannot be question of
Court
substantial
is
question
not
of law.
formulating the second one. Third, not the same language. Third one, that will be one.
Third model, my lord, see, post question of law is whether by not what is along addition even that.
No, third, not third. Fourth, fifth. First, fourth, and fifth. Fourth, fifth include his one draft one.
My ambulance, my lord. Yes, for his, my lord, there can be some substantial law, my lord. For his case, my lord, the answer is
He
only.
said there's no substantial question of law for him also. I mean,
Yes, my
first
lord,
one.
my argument, my
Now
lord.
say that he may have, but at least.
At the most, my lord, at the most, I am saying he may have, at the most, my lord. My past assumption is there is no substantial question of law in this case, my lord.
You challenge it. I'm formulating for three substantial question of law, and we're fixing it for hearing after 4 weeks. All right.
Okay.
That's all. Thank you. 4 weeks. Unless we.
Your Lordship, I appear for private respondent numbers 5 to 24.
Yes.
Will be filing our affidavit during the course of the day. Ready.
From the date of
Yes, yes.
from the date of vacancy, or from the date of eligibility, or from the date of adopt.
Date of adopt.
Recently, there is a
I-
judgment of the Supreme Court. 4 months, 4 days back.
3-4 days there.
3-4 days back.
No, but that
But this court
has some view that I'll place this.
granted,
Well, list on 7.
but Mr. Petitioner, consider that. Petitioners.
7.
Mr.
7.
Deepang, consider appearing for the respondent, private respondents.
5 to 24.
5 to 24 submits that he would be filing the affidavit in opposition during the course of the day. Mr. Helper, my appears for.
My lord, for 2, 3, and 4, my lord. 2, 3,
But look,
2, 3, 2, 3.
my lord, in this case,
Understanding counsel for power
power
department.
department, and
And Mr. Iram, learned senior additional 84, respondent number 1.
in this case, my lord, the grievances of my brother Pangin's client are addressed to in the affidavit by the state government only. Their rota, that quota system is implemented. Then P1, D1, DR, these are already there and it's not affected. But what my brother is apprehending is that if we are given the notional promotion, then there is a difficulty that their seniority might be affected. But at the same time, if we are denied, our seniority are affected that way.
We'll
But there is a that I'll not disclose now, my lord.
in view of the submissions.
Yes.
No, not in view. Let this, on the prayer of land consent for the we'll list this matter after 2 weeks.
No, on 7th.
Why?
So there is urgency, my lord, because my brother saw 2 occasions to file the reply.
You don't want to file reply.
I was not even implemented, I implemented myself.
Okay. So government,
Government has already filed, so therefore, my lord,
okay.
Yeah.
7 for what?
7
for admission.
admission here.
List the matter for admission on 7. Admission hearing on 07/08/2020.
Much obliged.
Yes, counter affidavit.
My lord, counter affidavit will be required some more time. Basically, they have challenged the Central Act, my lord.
Okay.
If the Central Act goes, my lord, then automatically our notice also goes.
Which for the main respondent will be Union of India.
Yes, Union of India. Mr. Marto Kato, my lord, he was here this morning.
My lord, in this case, I am appearing for the respondents, my lord, number 2, 3, and 4, my lord.
2, 3, and 4.
So in this case, my lord, the similar issue, my lord, has been decided by the Supreme Court recently, my lord.
Decided.
So yeah, issue involved, my lord. So I need 2 weeks time to just obtain the instructions and the order of the court. So they appraise the court regarding that.
You are for respondent number 1 and 2. 2 and 3.
No, my lord, 2, 3, and 4, my lord.
Okay, so in that case, nothing remains if it has been decided.
Well,
Anyway,
My lord, even I'm also looking for that judgment
Ah.
because that judgment was reserved.
none appears for the petitioner on.
My lord, for item number 14, I am appearing virtually, my lord.
Okay. You just take that. MS.
My lord, Tania Roy.
Appears for the petitioner. And Mr. Arachnabam London, additional advocate general for the state.
4 and 5.
State of Arunachal Pradesh. Respondent 4 and 5. So you'll be only for 5. Commissioner of GST and Central Excise.
yes, my lord.
Only 5, my lord. Sorry, only 5.
5. Mr. What's your name, please?
MK Boro, my lord.
MK
MK Boro. Yes,
MK
my lord.
Boro, London Council, appearing for the respondent number 2 and 3, has submitted that the issue involved in this writ petition has already been decided by the Honorable Supreme Court of India. Therefore, he seeks a week's time to flesh the judgment of the Honorable Supreme Court.
My lord, if I may, the Supreme Court is yet to decide on the point of whether the judgment will be applicable retrospectively or prospectively. My lord, that part is pending before the Supreme Court and shall be
Sir,
taken up this week.
Do you
So,
have the judgment of the Supreme Court?
no,
Do you
my
have
lord,
the judgment of Supreme Court now?
my lord, no, my lord,
It's his submission will list after a week. We'll see.
my lord, my lord.
Considering the submissions of the learned counsel for the respondent 2 and 3, list this matter after a week so as to. After
My
a
lord,
week.
can it be fixed on 6th, my lord? 6th of August, my lord.
We'll see. After a week, obviously. On the next day, the learned counsel for the parties shall place the judgment of the Honorable Supreme Court. Yes.
This is the same issue, my lord, where I have at least certain, my lord, the submission of the fake documents and thereby getting the tender. Against the interim order, my lord, I have preferred an writ appeal. And this court was pleased to observe that since matter is to be decided by the writ court. So an observation was there as expeditiously possible. It will be decided and an interim protection was given.
Interim protection is there.
Interim protection to the extent that 30% of the total my lord, bid amount contracted price shall not be released to the private respondent number 7.
Yes.
Against that also, my lord, we had went to the my lord, Supreme Court, and the apex court has also my lord, disposed of the my lord, SLP by observing that my lord, with a reasonable dispatch, my lord, the honorable single judge would dispose of the matter. So in fact, the matter was heard on 20th May. But during the course of hearing, as the respondent desired to file their affidavit, so matter again, my lord, had been adjourned. So now pleadings are complete. Lordship may take up the matter, my lord.
Ready?
Lord, no, parties are ready. My lord, this relates to my lord, the
So 15 minutes will resume after the completion of all the. At 2 will start at all other cases.
Make please, your lordship.
Yes, where is Mr. Kato? Where are these judgment orders?
My lord, lordship will find at page, my lord, 45, my lord.
45.
45 onwards, my lord.
Where is Mr. Kato?
Lordship may take up at 2 p.m. I will just inform Mr. Kato.
Hmm?
I will inform Mr. Kato at 2 p.m. Lordship may take up.
We'll take up next week.
On Monday then, my lord, 5th of, on Monday, my lord, next Monday.
Or Mr. R.S. Mr. Land Council for the petitioner. On 23/07/2024, this court has granted Mr. M. Kato learned BJC for respondents. To obtain instruction as to whether the present writ petition is covered by the order of the, this is order and judgment and order of this. Order of this. Or in the case of, in passed in writ petition 6232 of 2020, dated 29/09/2022. Yes, 406, WPC 406 of 2022, dated 30/09/2022, and WPC number 7018 of 2023, dated 08/20, 08/12/2023. Or the learned DAJ is not present, is not present today. Accordingly, and we will this matter after a week.
On next Monday, Lordship allows.
On
5th,
Monday is what?
5th of August.
05/20, 05/08/2024. Mr. R.S. Mr. Learned Council undertakes to inform the learned DHA
My lord.
For necessary instruction to be placed on the next date. You inform him.
My lord.
If these are covered cases, why unnecessary?
My lord.
May I please, Your Lordship? This is an application under 439 Code of Criminal Procedure.
Yeah.
I'm praying for the bail of Matam Lete, who was arrested on, Your Lordship. He was arrested on, the FIR was lodged on 5/11/2020, and he was arrested on in Konsa on 13/11/2020. Your Lordship. That is the, I was arrested almost, I mean, in jail Hazard, almost 4 years, Your Lordship. I mean, 3 years, 8 months, I mean, jail.
Do you have the updated LCR?
Yes, Your Lordship.
Yes.
Your Lordship, regarding all the LCR being called from the lower courts and all, I'd like to submit that at the at the end of the evidence, when evidence has concluded, the trial magistrate or trial judge will question the accused person under section 313 Code of Criminal Procedure, my lordship.
Yes.
And only that statement can be taken into account while passing a judgment for whether conviction or acquittal. Rest, none of the statements by the accused or by anyone else will be considered, your lordship. 313, shall I read it out, your lordship? Code of Criminal Procedure.
Yes.
Power to examine an accused. In every inquiry or trial for the purpose of enabling the accused personally to explain any circumstances appearing in evidence against him, the court may, number A, may, at any stage without previously.
Why you are reading that?
The LCRs, since they have come, they may have statements, lots of statements for me or against me. So only statement that would be considered by the
So
trial
according
judge.
to you, only the 313 statement has to be
The
considered.
judge will, judge will
by this-
consider,
by
judge will
this court.
consider that as a major merit.
Not the other materials.
Other materials, because it can be retracted, your lordship.
So
This cannot be retracted. Even 161
forget
statement.
about it, will come later. Why? You tell us what is the grounds for granting your bail?
Okay, lordship, I'm paying for bail on the length of incarceration, your lordship.
Yes.
Recently, Supreme Court, headed by Justice Ujjwal Bhuiyan, has passed a judgment. I'd like to bring it to your notice. This one. My pray for bail is only on length of incarceration, your lordship.
That's all.
And I have two other judgments also, lordship, if I need.
Which paragraph you are relying on?
Lordship,
What judgment?
page 12, para 22. 22, 23. 23, 1. Justice Ujjwal Bhuiyan, lordship, you got it.
When you were arrested?
I was arrested on 13/11, your lordship,
13/11 what?
2020.
22.
20.
13/11/2020.
2020. 3 years, 8 months, 8 months, your lordship.
So this case was of 489 and 489B and C.
No, no, Your
In
Lordship.
the case you have relied on.
Yes, sir.
But your present case is 302.
302. There's a Rehan case, Your Lordship. That
Yes.
is, there is 302, Your Lordship.
Sure.
I've submitted, Your Lordship.
And it was of 2015.
What?
Therefore, there is a delay in trial and long incarceration. Yours is of 2020, just 3 days.
4 years almost, Your Lordship. It's almost 4 years. Almost 4 years, Your
Not
Lordship.
almost 4 years, 2011. 18/11/2020.
No, I was from my date of
20
arrest. Your Lordship, please consider from my date of arrest.
Nearly 4 years,
Nearly 4 years. That's
more
what
than 3 years only.
3 years, 8 months.
And
more
in
than
this
5.
case is 2015.
I have also
nine
submitted
years.
300, which is 4 years in.
There's a difference, sir.
In 4 years in
And the
correction.
cases of
You-
fake currency 489, right?
What I'm,
That is, it's all settled. You cannot. Every accused has the right to have a speedy trial. 9 years and 3 years is a huge difference.
Your Lordship can kindly go to Rehan's case, Your Lordship. It is 4 years, Your Lordship. Now Rehan will guess.
India Kanun. Delhi High Court.
Yes.
Is Delhi High Court.
Yes, Your Lordship. Hmm.
Yes, there's no flight risk.
Lordship, there's no flight risk. I'm local person, Your Lordship.
What local person?
You asking me whether
You
I'm
are
a
from
flight?
other district.
Other
Trial is on.
Trial is going on here, Your Lordship.
Place of
In
operation.
Tirap, I'm from Tirap district. Within the state, Your Lordship, within the state is.
So you cannot say that there is no flight risk.
Within the
Anyway,
state.
what do you say? That's all.
Yes.
Long incarceration, that's your only ground. You're relying on the Supreme Court judgment.
Yes, Your
That's all. Even if it's 302.
Lordship, there is a 164 statement also I have annexed. So that will, that 164 statement in my petition 134 to 138 page.
Page
Hmm?
134.
134.
Just wait.
So one of the accused has
Where it is? 134.
134.
134.
134. Annex K, Your Lordship.
Annex K, yes.
That is the one of the 164 statements of one of the co-accused. Your Lordship. If you can, page 4, Your Lordship.
Mhm. Yes.
Last para and I'll read the first para and the last para. Your Lordship. I used to work as a farmer in my village and I used to live in difficult life. This is one of the co-accused, Your Lordship.
Page.
Annex, page 4 of the annex, Your Lordship. Page 137.
Yes. Yes.
This one I read, last one.
Hmm.
On 5th October 2020 in the morning, I was given another 10,000 in cash by Mr. Vijay Busas on behalf of Mr. Lisi Roni. We left Naharlagun at 12:01 p.m. for Kharsinga and I picked up Beggy Tinali by saying to Madam that he is the laborer of Nisi and even Madam agreed to let him inside the car, inside the Indica vehicle, which I was driving. On reaching Kharsinga area where the waste dump where waste is dumped, demented Khoyam, who was sitting in the last seat of the vehicle, attacked Madam with hammer. Madam screamed a little, but she became unconscious. I was told by Demriat Koyang that she is dead. Then he got down at the turning point, turning before the block point. I got frightened and lost my senses, seeing the blood and caused the accident. I didn't care if I died or live. I was carried away by my greed for money, and that is what I did, along with Demriat Koyang. I have not been mentioned at all, Your Lordship. So that will bring a contradiction beyond reasonable doubt. You have to create a doubt, Your Lordship, in the trial court's mind.
So according to you, since your name has not been mentioned here, 164.
Yes, admitted that he has done. So I'm not saying that I am to be acquitted, Your Lordship. I am praying for bail so that I can prepare my defense. And 4 years, almost 4 years, Lordship, that's quite a long journey.
Why don't you approach the trial court? They must be better in place. Trial court will be better in place to.
No, so I
know
did
the
approach
status.
once, it was rejected, Your Lordship.
Yes. So that is before the trial is started. Yes.
Yes, Your Lordship. Your Lordship has rightly pointed out that only on the sole ground of incarceration, he cannot be seeking for the bail, Your Lordship. The 437 of CRPC clearly states that there are grounds on which the court need to look into while granting bail, Your Lordship. Your Lordship, I have also marked in the LCR, Your Lordship, because since they have not annexed the entire document, Your Lordship.
Trial has started.
It has started, Your Lordship. Your Lordship will
only.
only 4 of the out of the 38 witnesses, only 4 of the witnesses has been examined till date, Your Lordship. Your Lordship will also consider the fact that he is the one who has, in connivance with the main accused, the prime accused, has arranged for the driver, has arranged for the other co-accused who was involved in the murder case, Your Lordship. Your Lordship will also consider that the statement of those witnesses has not yet been taken place, Your Lordship. There is the statement of those co-accused as well as of some prime witnesses, Your Lordship. The person who was also co-accused, who has been discharged, and that discharge application, the order is under CAV, Your Lordship. All those witnesses and accused, their statement has not been recorded till yet, Your Lordship. There is a chance that he might, in the bail, if the bail is given, he might in any way temper with and influence the witnesses, Your Lordship. Your Lordship, on that regard, I have also a judgment of the Honorable Apex Court, where it clearly says that the period of incarceration by itself would not entitle the accused.
Trial is what is stated now evidence.
For examination of the PWC, Your Lordship.
PWs, huh?
Only 4.
Only 4 out of
38 witnesses, Your Lordship.
38 out. Then
Your Lordship will see the even the statement of all the witnesses against who has deposed against the accused, Your Lordship.
present accused.
Yes, their statement are also yet to be recorded.
Only 4. Why only 4?
Your Lordship.
It's been nearly 4 years.
Yes, Your Lordship. Not aware of the fact, because otherwise there was also an order from this Honorable Court to expedite the proceeding, Your Lordship.
Yes. Only 4 as of now.
Yeah, only 4. Also, Your Lordship, the statement, I have gone through the statement of the applicant himself under 161, Your Lordship.
164.
161, Your Lordship, because
it is?
I have flag marked the same, Your
What is
Lordship.
the name of the accused?
Kapwang Lete Loang.
Kapwang.
Yes, Your Lordship. Your Lordship will also see that 437, the ground on 437 clearly states that it's if the antecedent of the accused, Your Lordship. Your Lordship will kindly go through his statement, Your Lordship, the antecedent of the accused, Your Lordship.
161.
161.
Then what you're saying, 437?
437, Your Lordship, clearly states that there are three grounds on which the court need to consider while granting bail, Your Lordship. One is the nature of acquisition and the severity of punishment in case of conviction and the nature of supporting evidence. The other is reasonable apprehension of tampering with the witnesses. And the third is prima facie satisfaction of the court in support of the charge, Your Lordship.
But Supreme Court nowadays is heavily on
Your Lordship, I would also like to,
wrong
yes,
incarceration.
yes, absolutely, Your Lordship. I would
speedy
like,
Trial, principle of speedy trial.
Your Lordship can always direct for a speedy trial, Your Lordship, but then only on the ground of incarceration, Your Lordship. Since my learned,
How do we say that there is a likelihood of tempering the evidence?
because if Your Lordship will go through the statements of other witnesses, Your Lordship, there is a clear, none of the witnesses were directly connected to the prime accused, Your Lordship. This person, the applicant, was the main bridge between all the accusers, Your Lordship. He was the one of the accused.
It's okay. It's all this.
Your Lordship,
may or may not
if
be,
he is
but
granted-
it's a matter of trial. You
But
have
then-
filed the charge sheet.
Yes, but then if he's granted bail, Your Lordship will say after the filing of the charge sheet, 161 during the deposition, 161 is only relied upon, not taken as an evidence, Your Lordship. Now, if during the deposition, Your
And
Lordship,
then for
if
the last when the charge sheet was filed?
there were three charge sheet files, Your Lordship, one after another.
When did
The last was filed. The last was filed on 15/1/2022, Your Lordship.
Yes. It's been more than 22 years.
Yes, Your Lordship.
You have examined only, 4 witnesses out of 38.
Yes, Your Lordship. Your Lordship, if I may give the judgment, I would like to rely upon
Pass the order.
paragraph 10 and
Mr.
13.
Lordship, I'll read out from Justice Mia's, or have you read it or shall I read it out?
Which one?
The judgment that I have relied on.
Okay.
Thank you.
Heard Mr.
P. Kalita, Your Lordship.
P. Talukdar, learned counsel for the petition, the applicant. And also heard Mr. MS Tijini, learned medicine for PP for the state. That's all. I'll pass the order in the check. We'll see. I'll
Much
go
obliged.
through the-
May I, Your Lordship? Your Lordship, I beg to mention item number 28 on behalf of 20%.
We'll see. Wait for some. 16 also. When it is.
May I sign, my lord?
Yes.
Here, my lord, I am taking some time to file reply, my lord, to every position filed by the state respondent,
Reason that,
my lord.
whatever the respond number 7.
Seven, my lord.
Service.
Service, my lord, we took step, my lord. I believe my data was sharp, my lord.
Last steps, when did you take the last steps?
On 16/11/23, my lord.
Hmm.
16/11,
Take press steps.
my lord.
And Mr. El Perman, and counsel for the petitioner, who submits that he may be granted some time to file affidavit in opposition, affidavit in reply
My lord,
to the affidavit in opposition filed by the state respondent.
my lord.
the learned counsel for petition is granted 3 weeks time to file affidavit in reply as per this book. Next paragraph, office note dated 26/07/2024 reflects that the service of the service report in the school registration number 7 is still awaiting. Having considered that the affidavit, the steps was taken by the petitioner on when last
23, my lord, 23/11. 16/11/2020.
16/11/2022. Come on. The then constable the petitioner is directed to take press steps for submission of notice of the school number 7 within 2 days.
3 days.
3 days. List. According.
My lord, interim is dated.
Interim of the person, yes.
Number 21.
Here also, my lord, I am praying some more time, my lord, to file affidavit in reply, my lord, to affidavit opposition. Filed by my lord, respondent number 2, my lord.
Mr. Helper. When consulted by the petitioner, means that he may be allowed to, he may be granted 3 weeks time to file affidavit in reply. To the affidavit may be filed by the respondent to prayer the law. This after prayer the law. This after 2 weeks. Next paragraph. Office note dated 26/07/2024 reflects that the answered notices have been received. Under notices in respondent 3 and 4 have been received. In view of the counsel for the petitioner to take basis steps. Respondent. 3 and 4.
My lord.
3 and 4, right? 3 and 4.
It's a 4. My lord, 3.
No, 3 and 4.
Yes, my lord, 3 and 4.
Within 3 days. Just after 3.
Problem.
Number 24.
May Lordship.
What is
Lordship, this is a joint application, Lordship. Filed by accused
Where is it
complainant.
listed today?
Listed, Lordship.
Listed for orders today. Why?
Also, actually, last occasion, I have to produce Lordship updated case diary.
Cities called for.
Lordship, no, updated case diary has not come, Lordship.
To be produced again on the next day.
Lordship.
And
last order.
Lordship,
You
that's
have
why.
to return and produce on the next day.
Lordship, it has not come, Lordship.
Lordship.
Let this matter be listed. Mr. Deebam, Learned Counsel for the petition. Petitioners.
Yes, Lordship, petitioners.
This which is submitted, it is submitted by MS Elhage, Learned Medicine PP, that he has not received the case diary.
Updated
Which
case
is
diary,
supposed
Lordship.
to, updated case diary, which is supposed to be placed today, comma, for which she pressed for some time to produce that case diary. Updated case diary.
Please to list on admission column, Lordship. Admission column, Lordship.
Let this method be listed. List of prayers allowed. This matter for admission hearing after a week, so as to enable the
on admission
counsel for the allotted additional PP to produce the updated case diary.
Obliged, Lordship.
Number 25.
Why this is for orders today?
Orders? I think
Why
it
this
was-
has been listed for orders today?
It should have been for hearing, Your Honor. No, so actually, last occasion, LCR was
It's
called
in the-
for.
LCR is there.
No, so it has this, there.
It is noticed that her MS has been the counsel for the petitioner. Petitioners.
Yes,
And
joint
also her
petition.
MS Elhagel and additional people for this. Next, it is noticed that the scanned copy of the Sessions case number 25 of 2022 from the learned investigation session that we get has received this matter for admission hearing after a week, next week, after a week.
Yes.
So, obliged.
So, where is the order of Supreme Court? Is there any observation? Is there any observation by the Honorable Supreme Court?
Observation to the extent that reasonable dispatch the matter to be disposed of.
Reasonable dispatch. Okay, then. And what is the order of that
Writ appeal.
writ appeal?
Yes, there it's
It's not a part of this record.
my lord, I have given
All
this
these are not parts of the record.
my lord, the subsequent, my lord, all these things, my lord, I have filed an IA. There, all these subsequent events are given, even the documents, my lord,
In the IA.
in the IA, my lord.
So IA, so this was, you have said there was a controversy.
My lord, I filed this IA, my lord, for amendment or my lord, my lord, to bring the subsequent, my lord,
So
development.
amendment you have.
I have forgone. I have, my lord, you done that, my lord, only, my lord, the subsequent events and the documents that had happened, only for that purpose, that was, maintained. Now, the writ appeal order, your lordship will find
So you are not pressing
Page-
this.
page
so you are
49.
not pressing this IA.
it may be,
Right.
my lord, yes, my lord, this may be treated as a, my lord, part of the, my lord, subsequent event and the part of the record, that much. my lord.
No, if you are not pressing, if you have forgone this, then why you should take it?
But these are the subsequent development which are, my lord, has, my lord, developed subsequent to
Which
filing
are
of
the
the,
facts, we are not supposed to take it.
my lord.
We are not supposed to take it notice. You filed an IA
Lordship,
or basically amendment, bringing some certain documents.
documents.
Then you have decided not to press the IA. Why you should
No,
take
not,
notice
not,
of this?
not to treat it as a, my lord, application, bringing on record certain, documents and the facts which were developed subsequent to the, filing of the writ.
So initially, what is your prayer? Why you have, your technical bid has been rejected
My technical bid has been rejected.
and you are
That-
challenging,
That was
on the
challenged.
basis of-
Initially, there was an interim order. That interim order was vacated.
yes.
Then we have come to know about a particular document. We have filed an writ appeal. Then we thought it that fit to go for a review because that was not brought before the honorable single judge. So we drew the writ appeal. We preferred an review application. That review application has been dismissed. With all the, my lord, facts and documents, we preferred another writ appeal. There, this court has, my lord, observed for disposal of the entire writ petition as expeditiously as possible, and also an order was passed to the effect that 30% of the contract price shall not be released to the respondent and matter to be disposed of.
What is the status of the work? The work, it's going on.
It's going on. It's at 30 months work. It's just 3-4 months you have to.
So can we take note of all those, the
These
documents?
are all
which
part
you-
of the records, my lord, in either in the writ appeal or review. I have just condensed it to the, my lord, in a, my lord, by this particular application. Because just now I have said regarding the writ appeal, my lord, this things has happened. So that particular order is there. I have said about review, that particular review application is there.
Where is that order?
My lord, the judgment of the writ appeal.
Division bench, yeah.
Yes, my lord.
Order of
Page,
division
page,
bench.
page 49.
Page 14 of.
49 of the IA, my lord.
Huh?
Page 49 of the IA. Oh, my lord, 43, my lord.
43, 44.
It starts from 43, my lord, relevant portion is at page 49. Judgment. Page 49, my lord, paragraph 12. Insofar as plea of fraud and misrepresentation and or use of fake document raised by the appellant's counsel by referring to form as submitted by the respondent number 7 and mismatch of the figures in the certificate prepared by his certified accountant is concerned, we find that such a plea has been substantially raised by the writ petitioner in the writ petition in paragraph 8.3. However, the learned single judge has not dealt with the same in the impugned order. Be that as it may, said aspect of the matter would have to be gone into and decided by the learned single judge in the pending writ petition at the stage of hearing of the petition, which stage is yet to arrive. We are informed that although the departmental authorities have filed their counter affidavit in writ petition, the respondent number 7 yet to file counter affidavit in the writ petition. Unless the pleading are complete and writ petition taken up for hearing on merit, the allegation regarding use of fake documents and or preparation of fraud by the respondent number 7 cannot be determined by this court. It is no doubt that the third allegation raised by the appellant alleging uses of fake documents by the respondent number 7 is a serious nature and if found to be correct may entail serious adverse consequence upon the said respondent. However, it is to be borne in mind that unless a proper finding of fact is recorded by the court establishing the aforesaid plea, no order can be passed by this court merely on assumption of fraud. In order to avoid any prejudice being caused to either side, we refrain from making any further comments in the matter at this stage. Now, paragraph 15. For the reason stated herein above, we are not inclined to interfere with the order impugned in the writ appeal. We therefore dispose of the writ appeal with a request to the learned single judge to hear the writ petition on merit and pass final orders therein by taking note of all pleas raised by the concerned parties as expeditiously as possible. In order to ensure that the interest of the appellant is protected till such time, the writ petition is finally disposed of and keeping in mind the public interest at large, balancing the equities, we direct that altogether not to release authorities not to release payment in favor of the respondent number 7 beyond the ceiling of 70% of total estimated cost of the work.
Is it propriety? Can this court take up this matter? Because our part of the division bench. Wrongly, rightly, we have.
Lordship has not commented anything, therefore refrain from making any comment because it will be decided because with a opportunity to the other side. Now
Still, we have recorded that at para 8.3 you have mentioned all this thing.
It is in the yes, my lord, the pleading is there. My lord, I had shown the paragraph 8.3 that pleadings are there. It is not that
I'm just asking all the parties.
Para 10, my lord, there is a prima facie finding recorded.
That's what I'm saying.
And as well as at page 49, my lord.
Tomorrow, I mean, that's why I'm asking.
We leave it to your lordships, my lord.
No, you should don't leave it. You suggest us. I have no issue to take up the matter, but if you did any item of, reservation, because we have, as sitting in the division bench, we have referred to the non-single bench. There's no bar as such.
But the consideration before your lordship or the scrutiny is in the writ appellate court was confined to the interim order, whether that was correct or not.
Whatever, but then we have seen the materials and we have observed something also.
If they have any reservation, my lord, in that case,
paragraph 10.
I don't have any reservations, my lord, but
No, you be very frank, no issue.
no, I'm not.
If you have no problem, I'll take up
I
the
don't have
matter.
any problem.
If you have any reservation.
I don't have any reservation.
Because I was a part of the division bench. Then it may be taken up
I don't have any reservation.
before any other court.
if they don't have any reservation, perhaps lordship can take up.
What do you say? You suggest? Senior counsel.
My lord, I don't have any reservation, nor he has
I
any
don't-
reservation, so lordship can take up the matter, I believe.
No, if you don't have any problem, I'll hear it.
I don't have any problem.
It was only confined to the interim order and to the extent whether interim order was right or not.
But there is some observation.
That
As
will
he
be,
said,
that
oh,
to be
we have
decided
not
by the
decided.
single judge.
Yes.
That to be decided by the single judge. Prima facie observation, even my statement has been given, so my lord, view comes. Now, if you can So basically, my lord, the RFP was issued, my lord, on 16/10/2023.
Let's wait. Who has submitted this Perawa's comments? This one? Perawa's, this one. Comments, Perawa's comments.
I think mistakenly it has been placed. Mistakenly, I think how it has come.
This is by whom? Yours?
It,
The respondents?
because it does not reflect the person who has written. Forwarding letters. 23 of 20. ठीक है इसमें देख लो in that pairwise if Otto's name is not there, so how it has come a part of record.
Yes.
Well, the RFP was issued on 16/10/2023.
Yes. 1610.
16/10/2023.
RFP.
For construction of the Doni Polo Airport to Naharlagun
Yes.
Road. And the total bid amount was 317 crore.
Yes.
The last date of submission of the tender was 15/11/2023.
Yes.
This date is my lord important, my lord. 15/11/2023, the last date of submission of the tender.
Last date
of submission of the tender, my lord,
Huh.
is 15/11/2023.
15/11/23.
Then stipulated period of completion is 30 months.
Yes. Yes.
15/1/2024.
Hmm.
An office order was issued whereby 4 tenderers were my lord, declared to be responsive. Is at page 26.
Yes. Why RFP is annexed letter? Anyway, RFP is
RFP is there, my lord.
page 29.
29, my lord.
Yes. Is page 26?
Page 26, my lord will find.
Found four bidders. to
4
be
bidders.
Responsive.
Yes, my lord, the serial number 1, 2, 3, 4. 4 is the respondent number 7.
Okay.
Who during the pendency of the writ petition was awarded with the contract. Now, my lord, so my lord, during my lord, subsistence of this, my lord, the particular writ petition submitted before your this court, the award was issued to him, my lord, letter of acceptance. And the reason of my lord, rejection so far as we are concerned, my lord, at page 27. Serial number 1. Navam Tulon LLP. Turnover below minimum qualifying criteria, RFP, serial number 1.7.41 at page 4.
Yes.
That is the only ground on which it has been rejected. Now this particular clause, your lordship will find at page 34. 11, page 35. small Roman one, the bidder should have average annual financial turnover gross of not less than rupees 158.50 CR on any works contract during the last available 5 years balance sheet duly audited by chartered accountant.
On any works contract during the last available 5 years, balance sheet. Duly audited by.
We have submitted before the Honorable Single Judge at that time of prayer for the interim, and also, my lord, what
This
we
is
have.
1.7.4.1, Roman 1.
Roman 1.
This is the only ground.
That is the only ground on which my lord, the technical bid of the present petitioner has been rejected. My lord, according to us, my lord,
qualifying criteria.
according to us, my lord, we gave an interpretation to the effect that any works contract during the last 5 years, one has to complete 158.50 CR. And Honorable Single Judge was of the view that this, my lord, the word average, so it has to be taken as an average of 5 years. Whatever annual turnover in each year, when the average is taken, that has to be 1.5.50 CR.
What honorable single judge?
My lord?
What honorable single judge?
On that ground, the stay order that was granted, that was Lord Chamber.
You
So-
just tell us
Lord Chamber.
what is the interpretation of the state?
Yes, yes.
You will go by the interpretation of the state,
exactly, my lord.
not by your interpretation.
Definitely. So, my lord,
Supreme
my
Court is
submission
very
is,
clear, is the author. The
they are the best.
standard clause,
Yes.
the interpretation of the author of
Interpretation.
the tender clause is with the author, not by us.
That's true, but then, mother, when it is prima facie appears the interpretation is
Yes,
something,
we'll see.
leads to some.
Yes, that's the only issue.
My lord?
Why should go for another?
No, other issues are there, equally issues are
Okay.
there. For a moment, my lord,
No.
let this issue be, my lord,
Yes.
kept aside, my lord,
Yes.
let this issue be kept aside. my
No,
lord.
this is the only ground first you have to address.
Lord Chamber, let us,
Is there may be ancillary issues,
Lord Chamber.
submission of fake, first you have to clear your stand.
Yes, madam.
Why you have been rejected, why you should not be rejected,
Lord Chamber.
according to you.
Yes.
Then we'll go to why the other parties has been allowed and all that, we'll see.
Lord Chamber.
First you have to clear your own hurdles.
Yes. Well, first, my submission is that
Yes.
this is in 5 years, any work, if the bidder executes, my lord, the work having annual turnover of 1.50. Because the word deployed is any works contract,
Yes.
that suffices the clause.
Should have had average annual financial turnover of not less than so and so on any works contract during the last available 5 years balance sheets duly audited by chartered accountant. Yes. Where is that chartered accountant?
Yes, madam.
Audited by chartered accountant, where it is?
Yes, it is there, madam.
Let's see.
Yes, madam. Now, madam, along with that, my submission, further submission is that even if it is, madam, taken to be, madam, the average of 5 years, then also tender evaluation committee doesn't have a power to reject on that ground alone. Because selection of the bidder will be judged by the Schedule D parameters that has been given to how the bids, madam, are evaluated.
Yes.
Now, this Schedule D is at page 61.
Yes.
Page 61. Well, first is experience in similar nature of work, Form C. This is with regard to clause 1.7.2.
Yes.
This is with regard to, my lord, 1.7.2. For a moment, if your lordship, my lord, comes to, my lord, that 1.7.2 as page 34 once again.
35.
1.7.2. The bidder should have satisfactorily completed the one work as mentioned during last 7 years, ending previous day of last date of submission of tender, provided that at least one similar work of 20% of estimated cost put to tender of rupees 31700 crore, that is not less than 63.40, should have been completed.
Yes.
And this has been clarified in page 41 of, that is part of ITB. Serial number 6. Value of similar nature of works executed during last 5 years. So 1.7.2, the first part is that during the last 7 years, he has to execute similar nature of work. And this 20% of the value work minus 63.40 has to be during the last 5 years. That is serial number 1. Then financial strength, serial number 2, Form A, that is Form A is the annual turnover and Form B is the solvency certificate.
Where it is?
This Form A, your lordship will find Form A at page 52. This is the format, Form A. Financial analysis, details to be furnished duly supported by figures in balance sheet, profit and loss account for the last 5 years financial years, duly certified by the chartered accountant as submitted by the applicant to the income tax. One, gross annual turnover of construction works, profit and loss. No, lordship will come to page 121.
Yes.
This is submitted by us regarding last 5 years. And in 2022-23, these figures are in lakhs. We have completed 158.84.13 lakhs. So it is 158.84 crores. So we would say that minimum criteria we get because of 22-23, we have executed work 158.84. Now your lordship may kindly come to.
So why this gross annual turnover on construction?
But if it is average is taken, my average is taken, it comes to 120.41 crore. But then there is an addition of certain percentage with regard to the years on which it has been executed. In that way, it comes to 136.09 crore.
How do you know all this calculation?
It is given
You
in.
have to clear only on this by your certificates. You have to submit this certificates showing that you have the annual gross annual turnover for 5 years 150 something 158.50. That's all. How you have submitted this 60? This gross annual turnover on construction of last 5 years. This is what? How much this is? 60? 6,000,
This is gross, my lord, taking all together, my lord.
yes. Then
This is all together, this,
from where you can show that you have this as per 174, 1.74, 7.4. It is as that 158.
that is, my lord, 2022-23, Lordship may see, my lord, this one,
Where
page
it is?
121. Under 22-23, 15884.13 lakhs. If it is converted to a crore, it becomes 158.84 crores. We said in any year. And interpretation given by the government is that average of all these 5 years to be taken, and then it has to be 158.50
Not
crores.
for a particular year.
Not for a particular year. We say for a particular year, they say that no, it has to be the average of the 5 years. So if the average is taken, my comes 121.41 crore. This has been mentioned in the writ petition as well, my lord.
Average,
Average
120 something, huh? 120 something crores, which
one
is
120.41 crore.
which is below the
Yes,
required 158.
Lordship.
So you are saying that it's not average,
It is not average. I said
it is a particular
it
year.
is particular year.
In any particular year for the last 1 year, if you have the average of more than around 150.50, then you are qualified.
I'm qualified.
Yes.
That is the issue. Now, second is that even if, my lord, their interpretation is taken, that mine is 120.21 crore,
Yes.
whether they have power to reject it. Because Schedule D says the marks has to be assigned.
Then will evaluate that.
The technical evaluation committee, how it will be evaluated, it is not there, but it is there in the, my lord,
It
the
is
SOP.
rejected by technical evaluation committee only.
Yes, but that has to be there in the record. They said they have assigned marks, so that record will reveal. And how the marks to be assigned, it is there in the SOP, which they also rely, and the clauses of the tender also says, my lord, you will find page 62. For score attribute of part A, refer pro forma 1, annexure 24 of
They are
SOP.
saying that that has been done.
They have said that has been done. They have to show that. Page 62, you will also make a listen.
62.
62. It is the same part of Schedule D. Note A. For score attribute of part A, refer pro forma 1, annexure 2 of SOP 2, CPWD Works Manual 2022. SOP 2014.
Yes, if they have done it.
Yes. So how it should be done, my lord, that what I wanted to say.
So why you are saying that the technical bid evaluation has the authority to reject on this point?
They will reject.
Who will reject that?
They will reject.
Consider on this ground.
Yes, but they will reject only if the Schedule D.
They have done it.
They have done it, my lord. They have to evaluate. Lordship, may kindly once again, my page 61.
Yes.
Now, so far as experience clause, I have shown, my lord, the 63.60 crores, my lord, is the similar works criteria. Their marks assigned is 20. And one has to get minimum to qualify, one has to get at least 10 marks. 10 marks. So now, whom will be given the 20 marks? And whom will be given, my lord, 10 marks? That has been given in the SOP 4. Someone, my lord, as per the SOP, if someone is having the prescribed amount, in that case, he will get 60% of the total marks. Suppose 158 crores, 0.5, if I have that 158 crores, even if it is taken.
Are you saying that that has not been done?
That has not been done.
But they are saying what? They say they have done.
They have done. So that record will reveal, but then before scrutiny of the records, the parameters and the criteria, how it to be judged, that's what,
Not
like,
go much into all this thing.
no, this has to be done, my lord.
See,
My lord,
how-
this
what-
is a,
How
this,
you have been rejected on under what clauses?
yes,
According to you, it was wrongly interpreted? By wrong interpretation of the clauses 1.7.4, Roman 1, you have been rejected. In other way, additionally, that apart, they have not done as per the SOP.
there's no question,
Calculation
my
and
lord, my lord, what my submission is, alternative, there's no question of that someone has to be 158.50 crore rupees annual turnover average. There's no, strict, my lord, no strict condition that 158.50 crore has to be the annual average turnover. There's no, because the marks are assigned. If someone puts 158.50 CR, then he'll be getting 60% of the total marks of 20, that is 9.6. He'll be getting only that much. Who will get the full marks? The one who quotes the double. 158.5.
If your average is less than 158,
pro rata, the marking will be there. Pro rata marking will, my lord, in the part 1, out of 100 marks, if someone gets 50, he is eligible. So there's no question.
even if you don't have a
158,
158 point.
exactly, my lord.
What it says?
Yes,
What
my
is
lord.
it?
Yes, but that's
Where
what
it is?
the SOP, my lord, move on from them. Even SOP, annexure 20. Well, Lordship, I have a look to this, my lord. That I'll be referring for other purpose, my lord. This one, my lord. This is the SOP which has been mentioned in the Schedule D, my lord. Performer 1, my lord, they have mentioned, my lord, is at internal page 195.
If you do the manual,
Lordship, my lord. In Schedule D, they have referred that the scoring will be from the part 1 performer 1. That is, my lord, the next one, my lord, internal page.
no,
195.
by this, what do you want to show?
My lord, page number 195, internal page 195, Lordship, may come in. Performer 1. No, my lord, just now the one I have given.
This one.
SOP, annexure 24. Has your Lordship?
The school one.
Yes. The next page, my lord, 195, internal page. This is performer 1 that has been given.
So, according to you, to work it out whether you have a gross annual financial turnover of this 158, you'll have to work on this.
You have to work
You
on
have to apply
whether I am having 100 crores or I am having 500 crores, it has to be worked on this. There is no criteria for rejecting. If someone doesn't get 50 marks in the part 1 evaluation, then he may be declared non-responsive.
I'm not satisfied. Suppose this is the condition of the tender.
Schedule
So-
D, Lordship.
So if you don't have a annual financial turnover, you are not eligible.
Malad,
Are you saying that you have the turnover? Even if you don't have the turnover, you have to work out, apply this.
apply
And
this.
if you work out that you are 158.
And if I get 50 marks, I am eligible.
That cannot be. Then it's contradictory. What is 50%? What do you mean by 50%? This says you'll have to have a 158.50 crore
Yes.
annual turnover.
Lordship.
Average annual turnover.
Yes.
Average is there. Average
Yes.
annual financial turnover
Hi.
of not less than so any works contract during the last available 5 years.
5 years.
Suppose if you are found to have, if you don't have this annual turnover of 151.50, even if you don't have this annual turnover, can we say that you will have to calculate and make it eligible?
That's what, my lord,
No, that cannot be.
the scoring is given
See,
on
let
that.
us not complicate.
No, this is
Are
not,
you saying that the authority has relied on this? Your rejection is on the basis of this.
this.
You are saying
So
that
this has to be.
you have the annual turnover of 1 year, 22 to 23, more than 158. That should be annual turnover, not the average of 5 years.
Yes.
That we can consider.
My lord, that
But
is,
saying that according to by showing this, what you are trying to say is, if I am correctly understood, even if you don't have 158.50, you will have to calculate this by applying this performer to have a 50%. Even if you don't have 158.50 turnover, you are eligible. That's what you are saying.
yes.
No, that cannot be. Okay,
That is the, my lord, terms and condition of the tender.
where it is.
Yes, my lord, this is, my lord, that Lordship will say, Schedule D, technical bid evaluation process. This is the process they have to adopt. This is the process.
No, that will be contradictory.
This is not the contradictory.
How can you have, if you provided, you must have this turnover. But then if you don't have that turnover, you go for some other criteria, calculation, awarding mark, and make you eligible. Okay, then what does this mean? It become redundant. Isn't it?
It is not redundant. my lord.
Then
It is the minimum.
this is for what?
This is for minimum what they are saying.
The bidder should have had average annual financial turnover gross of not less than so and so on any work done during the last 12 years, balance is duly audited, that's all.
That's all.
What does it say that it will be a minimum or
My
maximum?
lord, it is not that by seeing 158 crore is there or not, it will be rejected. It will be evaluated as per the, my lord, data given in the Schedule D.
Where it says.
That's what, my lord, this
This is only the requirement is duly audited by the chartered accountant.
that requirement is there, but then, my lord, who is, my lord, eligible or not? If someone is having, my lord,
See, it's not that if one criteria, requirement, condition of the clause. If you are not failed, if you don't qualify one, requirement in the clause, condition of the tender, you will be compensated in other clauses. It's not that every requirement and the condition of the tender has to be fulfilled.
yes,
So we'll go by simple whether you have this 158.
my lord, all this, my lord, all this, my lord, what my submission is, all these clauses, 1.7,
You show us the way in the condition for this purpose, 1.7.4. Point Roman 1. What is the criteria to be adopted and the procedure adopted to work it out whether you have this annual average turnover or not? What does it provide? Where it provides? That you will have to go
my
to
lord, this,
SOP, you will
my
have
lord,
to
this
go for all that.
RFP, my lord, clause 1.7 onwards, my lord, the
Yes.
various clauses are there, my lord.
Not barrier clauses, where is the relevant clause?
Yes, my lord, relevant, my lord,
Where-
all these
Where is
clauses.
the
what-
requirement to go with this?
No, what I am saying, wherever the, my lord, this so far as 1.7.2 is concerned and 1.7.4 is concerned, this will be evaluated as per the, my lord, Schedule D, that is technical bid evaluation. How my technical bid will be evaluated? So this, the part one, my lord, the
So this financial soundness has to be, not to be evaluated.
evaluated.
It has to be by the financial, at the time of opening of
Technical bid.
financial bid.
It is at the, malad, the process is by opening, Lordship will kindly see, malad, page 6.
No, that's what I'm saying. That's what I'm asking.
Lordship.
Rightfully, I'm asking.
Yes.
You are saying that they don't have the authority to reject your bid under this clause.
Malad, only after evaluation, if someone, malad, gets in the, malad, form C, that is similar work, if someone gets less than 10.
It doesn't say.
No, it is says, so
Only when
here it is
the
here, minimum
committee, the
qualifying marks.
evaluation committee has to see is the duly audited by chartered accountant. You will have to submit that, which you have shown in page 1, where it is.
Yes. So document is there.
Yes, they have been, it has been evaluated.
So these,
And they found that
no,
you,
these
you are less,
evaluation-
you are having a less than average of 158.50 crore for the last 5 years.
evaluation is not on that parameter. Evaluation is as per the Schedule D. Marks has to be assigned. That is the condition. It is, and this has been incorporated, malad, by them from the CPWD manual.
Marks for to calculate this 158.
Yes, malad. If someone gets 158.5 crore, he'll be getting 60% of the total marks. That is, he'll be getting,
If he doesn't get,
pro rata, it is mentioned, malad, pro rata, it will come down, malad. And to
then-
get the 20 marks, one has to have double the amount, that is 317 crores.
so that
If
means
someone's financial average turnover is 317 crore, in that case, he'll get 20. If he has minimum 1.7, 158.5.
so according to you, even if bidder doesn't have 158.50 crore annual turnover, he'll be considered as per that, and he'll be
All, my lord, whether he, even if he qualifies also, even if someone quotes 317,
above is something different.
Lordship. Below.
If below is there,
Yes.
you are eligible.
You are eligible, that has to be evaluated, and I have,
Then it's very simple. If you don't have that mark, I mean the benchmark or the average, 158 is the fix. You should have that for 5 years average or 1 year. If you have that, then only you will be eligible. Suppose 3-4 bidders are there. If everyone does have that, you cannot have exactly. Say someone will have 158, someone will 160, one of the 200.
Yes.
Then in that case, maybe the marks would be awarded. But if you are having a less than that, on your own submission saying that if you have a 120, according to their calculation, it's as simple as that. That you are not qualified as per this 1.7.4.
no, my lord, kindly just.
And that has to be evaluated, considered by the technical
My lord,
relation committee.
my lord, bid rejection is, my lord, so far as, my lord, when they can, my lord, Lordship will, can you see page 61? Bid opening committee during the opening of technical bids shall verify the following documents. Page 61. Bid opening committee during the opening of technical bids shall verify the following documents uploaded during bid submissions, original of downloaded copies as a prerequisite for carrying out further evaluation of technical responsiveness of bidder. So once it is uploaded, the required documents, that is, one is proof of payment of bid of rupees 25,000. Then registration under the CPWD or equivalent category. Then in addition to fulfillment required laid down in Schedule C, technical eligibility of bidders shall be determined based on the minimum score shown below. Now the markings are here given. So for serial number A, maximum marks is given 20 and qualifying mark is given 10. So if someone gets 10, in that case, he will be considered as eligible. And if someone gets less than 10, he'll be disqualified.
This is in addition to the 1.7.4.
No, madam. This in
It is
addition
not
to.
all- is it not for to find out whether you are having a 158.50? It is a different aspect to be considered by the bid evaluation process.
Malad, this is
Committee.
my submission 6.2. In addition to fulfillment requirements laid down at Schedule C, Schedule C provides what are the documents I have to upload.
Where is the schedule C?
Schedule
What
C,
is this 1.7 is what?
49.
Huh?
49 is this.
What is this?
My lord?
This is eligibility criteria. It's not schedule C.
Schedule C, my lord.
It's not schedule C.
No, this is schedule D, my lord.
Sir, that's what I'm saying.
Yes.
First, you have to have the eligibility criteria, fulfill all this 1.7. Then only this evaluation will come. This is in addition to that. It's a different thing to be considered. It's not for 1.7.4 to make you eligible whether you have the 158 or not. You have to work on this. It's not that. Am I clear?
My lord, they have.
Or am I confused?
My lord, perhaps I have not been able to, my lord, express myself.
No, I have understood.
My lord,
You are saying that.
my lord, the bids evaluation, I have submitted my bids. Then they will see, as per schedule C, whether documents I have uploaded or not.
That is
Number one.
That is what they have done it or not. That will see.
No, that
First,
they
that's
have,
why I'm saying 1.7.4
Yes.
is the reason
that
to
document,
reject your bid. So according to you, you have the annual turnover of more than 150 in the for 1 year. So you are eligible. Rest you don't have. What they are saying is the average of 5 years has to be taken. If the average of 5 years is taken, you are less than 158. Correct. That is one eligibility criteria on which you have been rejected. This Schedule D, Schedule C is in addition to that. Whether this has to be calculated, it has to be seen.
my lord,
Where does it say
yes,
that
Lordship may come to-
1.74 to find out 1.7.4? You will have to work on this.
Schedule C, Lordship will come, my lord, page 49. This 1.7 to 1.74, whether I fulfill or not, for that I have to upload certain documents.
Yes.
So this is schedule C. What documents I have to upload? These are the list of documents in conformity to the various.
Where is that then? That annual average income in the turnover of
Serial number 9.
Huh?
Serial number 9.
Certificate of annual financial turnover or fulfilled loss details for the last 5 years from chartered accountant
Not
in Form A.
not.
Yes.
So these documents, if they, my lord, on bid opening, as per schedule D, on bid opening, they will see whether I have.
Then anyway, then come to this is C. Then come to D.
Schedule D.
Huh.
Yes, schedule D, my lord, will find at page
In
61.
addition to the fulfillment requirements laid down in Schedule C,
Schedule C.
technical eligibility bill shall be determined based on minimum score shown. This is the addition. See, this 9, page 49, Schedule C.
Schedule C.
That you have submitted.
I have submitted.
That is, this is the requirement of documents. Form A you have to submit.
Yes, I have submitted.
And that form you have to have that qualification, eligibility, that 158.50 crores annual turnover will determine whether it's average or 1 year or 5 years average. We'll see.
Yes.
That you have submitted.
I have submitted.
They have evaluated it.
So
that,
no,
as per your financial turnover submitted by the chartered accountant, they are saying it is below the 158. Right? If all these documents are submitted and fulfilled, then in addition to that, this page 61 will have to be considered. Awarding marks and all these things. It's clearly said, in addition, fulfillment requirement laid out in Schedule C. Schedule C is one of the other documents is Form A, chartered accountant, annual turnover, average whatever for 5 years, that you have done. You are fulfilled. Submission you have fulfilled. According to them, you have submitted, but then you have you don't fulfill the 158. Average turnover for the 5 years is less than that, yet therefore you are not responsive. Now, having fulfilling all those documents in Schedule C, this calculation has to be in addition to that.
That's what.
Now, once you are one is, I mean, the eligibility criteria, if you are not fulfilled, though you have submitted the documents, but requirements are 158 according to them, you have rejected. So when this is in addition to that, that can be rejected one ground. And if it is not done, it's not that once it is fulfilled, if you submitted that, these marks has to be awarded, not that.
But my submission is that, so first, as per this, it will be.
Yes, you make your submission.
Bid opening prerequisites criteria is that 25,000 rupees receipt has to be given. And then Schedule C documents are there or not. If Schedule C documents are there or not, whether these are correct or not correct, that will be on verification or evaluation, that will be decided.
Yes.
That is the prerequisite stage.
Yes.
Now the second stage.
In addition to that,
After this
whether
is over.
fulfilled or not in Schedule C,
Yes.
this the Schedule D will be.
Yes. Now documents are uploaded.
Schedule D is the another, I mean, next or additional the process which they have to take. Isn't it? You have to evaluate marks.
First
and you have to
thing,
award the marks.
first thing, my lord, A, B, C, D document, whether I have uploaded or not. It is not that 158 crore or 168 crore. Whether A, B, C, D documents are uploaded or not. It is uploaded whether bid receipt is given or not. It is given. In addition to that, then the evaluation process is there. It is as per this. Now your lordship will kindly see why I am saying. This is so far serial number 1 is the similar work, 63.4 crores is required. Now, the 62 page, the 4 score attributes part A refer to performer annexure 24 of SOP so and so.
Yes.
Yes. Now, here you also see the maximum mark is 10. Maximum mark is 20. Minimum qualifying mark is 10. And the SOP says, if someone puts the minimum, then he gets 60% of the total marks. 60% of the total marks.
Sir, I'm not disputing this. That will be in addition to the eligibility criteria provided by them. Is not it? They have to follow these Schedule C and Schedule C, definitely. They have to do it. But for that also, that is a other thing to be followed by them. But first of all, you have to submit Schedule C Form A as per the eligibility.
Why I am submitting
criteria
if
provided by the.
If at the time of pre-qualification, at that time, if the technical evaluation committee has to judge that whether he is 158 is there or not, at that time only, then question of marking would not have come. That for minimum.
So according to you, to whether he has the
document is uploaded or
no. First, you have uploaded.
Yes.
To find out whether you have, on the basis of that documents, according to you,
I am eligible.
Whether you are eligible, whether you have the eligibility of or having the annual turnover of 158, you will have to go to Schedule D. That is what you are saying.
No, not turnover. Overall technical evaluation, whether I pass through or not.
That's what I'm saying. That is something different. That is in addition. First, where you are under which clause you have been rejected? 1.7.4. This clause D is not to find out whether you have 158 or not. Clause D is in addition to the documents which you have submitted. Whether your documents is in consonant or as required under 171.7.4 has to be decided by the authority.
By the authority as per this parameter of by giving marks.
Giving marks of this the one Form A.
Form A, Form B, every form, Form A, Form B, Form C, all has to be marked.
Where it is?
Page
61. 61.
Gotcha. This is with regard to Form C. Minimum one work criteria, maximum is 20 and the minimum is 10 to qualify. Now the SOP says the one who gives the minimum amount, he'll be getting 60% of the total marks.
Then
And one who gives the double the amount.
suppose this has been done.
Yes.
Your case is considered, awarding all these marks,
Yes.
right?
I have to get 50 marks from the part one.
Then
Total out of 100, I have to get 50.
yes,
And the part B, I have to get, out of 60, I have to get, the out of total marks is 120, I have to get total 60. That means from part B, I have to get 10 only.
then say if you get 60, then
I am qualified for technical bid, then my financial
where
bid.
it
will go.
is said, where it is, where it is.
To be eligible, page 62 clause E, just above 6.3. To become eligible, the bidder must secure minimum score of 60 out of 120 shown in the table above, with weightage indicated thereon, besides fulfill of the mandatory condition prescribed in Schedule C. That is, Schedule C is the last 5 years, my lord, the works executed.
Where it is, where you reading?
My lord, just above 66.3 at page 62, there's a clause E. That will be 6.2.1.E. To become eligible, the bidder must secure minimum score of 60 out of 20, shown in the table above with weightage indicated therein. Now, how these marks will be given, that is given in the SOP, the Annexure 24. Out of this, Lordship, if your Lordship takes up the SOP, while calculating the financial strength, annual turnover is given maximum 16 marks.
Where it is?
That's the SOP 24. Internal page 195.
16 marks, huh?
Average annual turnover 16 marks, and then banker's certificate is 4 marks. So that's how this 20 marks in the that has been given there, my lord, which is also available in the same my lord, SOP. Lordship will find in the clause 7.
No, that's why in that case, if it is, even if it is not 51, 158, if you calculate by going this, according to you, you don't have to consider a 1.7.4. There's not a reason to be, you should be rejected. That's what we are saying.
No, that is the benchmark they have given. 60% marks will be given to the 158 point.
Forget about 60%. Your rejection is under what provision? What
They-
clause?
They said
1.7.4.
4.
What does it mean?
Means they want to say that for last 5 years average, I don't have 158.5 CR. That
So
is their,
according to you, that's what I'm saying. If you accept your submission, then this 1.7.4 become redundant.
no, this,
It has got no meaning.
no, that's the benchmark has been given.
Not
This
benchmark, this is
Such a-
the eligibility criteria. And this is the procedure which you have to be. How you, correlate with this
No, what-
C, D and
what-
clause 1.7.4?
But why I am saying, my lord,
Suppose 1.58 is required. If you found to be not having 158, right? Even then, as per 162, clause C and D, C, no issue, you have submitted
yes,
the format.
yes,
And as per clause D,
evaluation.
evaluation. whether since you have submitted the documents in clause A, I mean
C,
Form A,
Schedule C.
Form A, or Form C, whatever, by awarding or considering and by awarding your marks as per clause D, if you get 60%, you become eligible.
Eligible.
So what's the meaning of having this 1.7.4?
Well, that is the minimum, the benchmark they have given eligibility, but then evaluation, because that is, the annual turnover is not the.
You correlate this.
You
correlate this C, D, SOP and that clause. That's 1.7.4. How you correlate this? It exists independently
No, no.
without any relation.
No, madam, this
Then-
1.7.4 says that minimum eligibility 158.5 CR.
Minimum eligibility, what does it mean? You have to first eligible. Having
My lord,
that one for
my lord, there is-
125.
my lord, that's what my submission is, my lord. There is no other clause that person who doesn't qualify the eligibility criteria, his bid will be declared
That
not
means
responsible.
enter the clauses, condition of the tender. It's a vague. There's no correlation. One contradicts each other. So and that,
Madam, that's what is the following, madam, so far as the other tenderers are concerned, including respondent number 7, they are following that criteria.
same thing.
They have done the same thing.
Same thing with
Madam,
you and that of other bidders also.
That's what I'm saying, madam. So far as the respondent number 7 is concerned, he doesn't have the one singular work of having 63.74 criteria.
How he has been selected?
That's what, madam, how he has been selected. He has submitted a document which was not non-existent on that day, because
How do we know? How this court will find out?
No, this all given, I am given.
It has to be proved.
Yes, these are all
How
materials.
you say that these are all fake certificates?
My lord, here,
Fake documents.
no, these are all.
One needs to have investigated and find it out.
No, no, my lord, these documents are available on materials on record, and the government having, my lord, realized that that was a mistake. Now they are relying a document which was not a part of the bidding document. That document was not submitted by them by the respondent number 7 in the, my lord, bidding
In
process.
that case, you file a criminal case.
No,
We
my lord.
cannot go into all these things at this
No,
stage.
no, that's what, my lord,
Your
what-
interpretation will consider,
yes.
but whether the documents are fake or not, how do we know?
No, these are, my lord, the documents are available on the record. These are
From
not,
where you are saying that these are fake?
but these are not, my lord, denied.
Huh?
These are not denied. My lord, simple.
They are admitting that is a fake documents.
My lord,
Are they admitting that these are fake documents which they have relied?
my lord,
And they have realized that,
yes.
they have realized
Yes.
that these are fake documents?
So they have,
Therefore, sorry, are they saying sorry?
so, no, they are not saying sorry. They are saying that he is eligible for the other account because he is having other.
Yes.
My lord,
Are you saying admitting that these are fake documents?
No.
He's saying,
In
Lord-
fact, lordship, document
Lordship-
which
yes, my lord.
if you are not saying it's okay, I'll
Yeah.
hear you.
Yeah, I'll come to that. Now, my lord, just, my lord, my lord, one document which I'd like to show, my lord. So far as, my lord, Form A of the respondent number 7, your lordship, you can see. Kindly have a look to the, my lord, page 123.
123.
123.
I don't know, because of whether, are you having the same problem? We're not in normal health. Since last 2 days, it was so horrible.
Yeah, it's, the humidity is
Are you
very-
experiencing the same thing?
humidity is very high.
The AC is also not
Yes.
working. My area, last 2 days.
Unbearable hot,
So
even in Guwahati.
at least
Humidity
I'm
is
not
very high.
having
What
a
I-
normal, I mean, health and as we don't have, we're facing a abnormal weather. My health is also not normal. Anyway, 123.
123.
Yes.
Now this, my lord, page, my lord, this year 2018-19. The figure is 172625. This is in lakhs. So if it is converted, it comes to, my lord, 1,726 crores. As per Form A, this has to be supported by the CA certificate. Now this CA certificate they has given in the next page, 124. Now the figure in 2018-19, your Lordship will see after 17.2 is missing. In the turnover Form A, they said 172. Here this 2 is missing. If it is converted to this page 124 into crore, it comes to 176.26 crore. But the turnover they have given, it is 1,726 crore. Now, why I am saying this is a fake document, false document, this is not supported by CA certificate. Not only that, your Lordship will find the next CA audited at page 25. This is again 1625, page 125. Total amount 17625. That again, that after 172 is missing. These are the authenticated document. Then Lordship may come to page 128.
Have you clarified? You asked for response number 7. Have you clarified this?
Yes.
All this?
It is, my lord, apparently it is a mistake and my learned friend is saying that it is not certified. Page 123 is certified by the CA, my lord.
Yes.
At the bottom.
Yes.
My lord,
How the CA can have this mistake?
No, my lord, not only that, my lord. This CA, my lord, this signature, these have been imposed here, my lord.
Then it will be a
This
criminal case,
itself
sir.
is a fake, because I am saying your Lordship will kindly see.
In that case, you will not be able to decide.
No, Lordship, no, I'm giving the materials here before your Lordship only.
You may file for this, you will file, get it.
No, that's a different issue. But then on this, my lord, the public interest is also concerned. My lord, Lordship will not, my lord, close my door for the, even for the public interest. For the sake of person who doesn't have the, my lord, minus this document, he doesn't have the eligibility of the minimum, my lord, similar works criteria. He doesn't have that. So therefore, that's what I am saying, my lord. Without there being any other document available in the, my lord, bidding document, the government is producing another document by way of affidavit in opposition, having 161 crores. Trying to say that he is having this criteria because this document, which is not a part of the bidding document. Not only that, the document required is for the building, for the road construction. And this document is regarding with the medical college construction. The government is saying that is the eligibility. The overzealousy of and different aspects will also come. Then your Lordship may kindly, why I am saying this is fake, your Lordship will kindly see. May I just point out?
This is one of the documents.
One of the documents. One of the there are other documents are also.
What are there?
Yes, same page, 123. Lordship may come.
Yes, I have seen in 123.
No, with regard to the signature. No, signature of this chartered accountant. Lordship has seen the chartered accountant signature. Page 123.
For that, I think we have this court has a jurisdiction has a limited.
No, Lordship will order for a whatever the fate of the case, my lord. But then considering the public interest, Lordship will definitely, ask the authority or employ either CBI or some other authority. It's a huge amount, my lord. This page 123, Lordship may kindly see the under the signature of the chartered accountant.
Have you filed any complaint, any FIR against this?
My lord, we are placing everything before this court, and this court is having ample power to direct the CBI inquiry or any judicial inquiry.
That is another issue.
Lordship.
Have you filed any complaint or any initiated any proceedings?
As of now, not, my lord. But thing is that, my lord, the clause of the tender document, your Lordship will say, the clause of the tender document says any forgery or
Definitely
fraud.
will consider this, but then problem is unless we come to a conclusion that whether this is fake or not, on our primary, we will not be
Ample material
At best to inquire into the matter, that's all. Until we find that these have been proved to be at least some inquiry
Yes.
by the some authority, how do we come to the conclusion that this is a fact?
No, my lord.
That would
No,
not
no,
be a
no,
proper for the writ court
No, no,
to
Lordship,
say
Lordship,
that on
Lordship, no, what they,
having a microscopic or thing,
not at
we
all. my
cannot
lord.
say that
Not
this
at all.
is a fact or not.
No, not at all. Madam, this figure so far is 1726, what the council has said, it is a mistake. That means 2 has been inserted wrongly.
Then he become ineligible.
Ineligible.
And so on.
Anyway.
Number 1. And this itself, my lord, what I am saying, Lordship, this is a very, my lord, interesting, my lord. I have come across first time this type of case, my lord.
You know, I don't hear for a whole day. Cracks, come to the crack. Yes.
No, I'll come there. No, why?
First point, 174, 1.74, 1.7.4 declare.
Yes.
And then we have seen your fake allegation of fake documents.
No, there's some.
Then next.
The
Third
next,
point, third
next time coming to this, madam, Form A, I am coming to this. These are specific pleadings are there, madam, in my, it is not that I am just showing. So far as this 120.
It's a tender matter, sir. We cannot manually go for whole hearing all day.
No, my lord, will you kindly find, my lord, the public interest, it's a 307 road
We are
construction is a
concerned
very
about the
important,
construction.
a
Who-
person has been
See,
given.
As the Honorable Supreme Court time and again said, we are not concerned who gets what, who gets the tender. We're only concerned about the construction of the, or the, for the public interest.
Yes.
Construction of the road, whether you construct, he construct.
No, when the, my lord, decisions are taken arbitrarily, even after, my lord, NG, my lord,
Because basically you are a contractor, I mean, all of you.
Yes.
Responsible. You are on all the profit making. What we'll see is, unless there is a, vitiated by fraud or illegalities,
Yes.
we are not interested, as Supreme Court says, who gets the work. We are concerned about whether the works is done or not. Is not it? Maybe you or maybe.
No, not exactly, my lord, that is one aspect of the matter, but then the construction has,
Guarantee,
not on whom the construction work has been
we
entrusted.
cannot have the guarantee that you will construct better or he will construct better. That will be by the,
No, therefore-
by the authority to choose.
No, therefore the criteria.
Basing on all these things,
Yes,
who
basing.
will be the best, they will pick up the best.
Now here,
So
my lord,
we'll not go into all those microscopic things.
it is not microscopic, it is apparent on the face of the record. They have.
Well determined, that's what I'm saying, sir.
Lordship.
That's what I'm saying.
Lordship.
I've seen it. Next,
Lordship.
come to the next ground, what is it?
Lordship.
Fake documents, I've seen 123, 124, 125.
No, not, my lord, there, my lord, another aspect what I could not point
Ah.
out, because he has said this CA sign is there. Now.
Now we'll hear him, we're yet to hear him. You
No,
may,
no,
you
no,
will have a
there- no,
right to
no,
reply.
Therefore, I'm pointing out to this particular UDN number.
Ah,
This UDN, my lord, 18-digit number, this is generated only once. It cannot be generated twice.
yes. Which one?
This UDIN number.
122,
Page
123.
123,
Ah,
UDIN number.
123,
That's
where it is?
UDIN under the contractor's signature, UDIN
123.
3. That's it. Under the chartered accountant signature, Lordship, is on the left-hand side below. UDIN 22302.
Ah,
Has your Lordship found?
yes.
This is an 18-digit number. It can be generated only once.
Hmm.
Now this 22, it reflects the year in which it has been generated.
22?
This, the first 2 digit,
Ah,
this UDN number, first 2 digit, this 22,
22, 3.
it signifies it projects the year in which it is submitted, that is 2022.
Yes, then?
Then the next 6 digit is the membership of the contractor's number, of the chartered accountant's membership number.
Hmm.
And the remaining 10 digit, it is auto-generated by the computer.
Hmm.
And this can be generated only once. Now your Lordship may come to page 128. Now, unique document identification number at serial, Lordship has got
Yes.
128. This is the same number.
223, so, huh?
Yes, this
Same
is
number.
this is the same number, and this was
UDI
UDI
number.
Lordship.
Yes.
And this was generated on 17/11/2022, just above.
Hmm.
And the CA has used it for the purpose of uploading his this 5 years documents. Lordship has seen, Lord.
Hmm.
This was generated on 17/11/2022, and this first two digit indicates the last two digit of the year 2022. And now, if you comes back to page 123, again, this is dated 10/10/2023. This is dated 10/10/2023. In 2023, it cannot be generated a year of 2022, which has already been generated on 17/11/2022.
No,
There-
it cannot be a date of, okay. So what do you mean by, what you're trying to say is, this UDI number
Yes,
generated in 2022
has been
on 17/11/2022
has
cannot
been
be
used.
shown to be 10/10/2023.
Yes,
Is it?
not that. The 128, this UDN number
Was
is
generated in 2022.
it is an
17/11.
authenticated to authenticate the document. CA has generated this number in the year 2028 with regard to these documents, the documents which are mentioned below, page 128. This UDN number, the purpose of the UDN number, my lord, gone, my lord. If any other document to be uploaded, then fresh UDN number has to be generated. It cannot be used for any other document or any other purpose.
We don't know. We're not
I
expert.
have the books, my lord. I have the books which will show me. I have the books. Why I am saying, my lord?
So why you are saying that this was generated in 17/11/2000? Anyway, you said since it was generated, this could not have been used to
Yes,
verify these documents.
yes,
I mean, for
Could not
these
have been.
documents.
yes.
Then
So these documents,
why you are saying 10/10/2023?
because they have given 10/10/2000 as if it has been generated on
Generated in
as if
10/10/2000.
Lordship, as if it has been generated on 10/10/2023.
He himself have incorporated this.
My lord,
Though the document, though the record shows that it was generated on 17/11/22,
yes,
he has put it. I mean, he has shown to have generated in 10/10/2023 by incorporating the different date
Lordship.
to show that this is
This document is also authenticated.
latest thing.
So this Form A is also authenticated. That's what he want to say.
Yeah.
And whether this signature itself is genuine or not, that I am not, because I don't have any other. But then so far as this UDN authenticacy of the document cannot
Then
be trusted. This is. Now your third, your lordship will kindly to the form, my lord, Schedule C, my lord. Form C, my lord, specimen is at page 53.
yes,
This is a Form C, page 53. It has,
how long you will take?
it takes some time, my lord. This is, my lord, I'll come back to 1.7.4.
Necessary, why should it spend? Hearing matters and fix. Huh? Yes. Wrap it up at 15 minutes, within 15 minutes. We'll have to hear them also.
We can continue tomorrow, my lord.
We want that the roads should be constructed.
Yes,
We're
yes.
not concerned about your profit and loss.
No, no, not at all.
Including the respondent number 7.
My lord, if I cannot, my lord, overcome the clause 1.7.4, I may not be able to claim for setting aside the award and give it to me.
Yes.
But so far as the award of the contract, when it is against the public interest, and it has been given to a person
Who is not eligible?
not only who is, my lord, doesn't have the capacity to execute the work, his maximum work, my lord, earlier executed not more than 6 crores.
We'll know, we'll see.
Yeah, I know, my lord, these documents, my lord, I'll point out to your lordship that
Yes.
they'll be giving the reply, my lord. To that extent, my lord, my lord, if I fail to 174, my lord, as what your lordship, I may not be able to claim. But the public interest is also involved. 307 crores, my lord, this is a very important road. It should be in a.
Well, in that case, if you are concerned with public work, we'll ensure that we'll direct the respondent number, state respondent to ensure that whoever construct the work should be as per the specification and within the time. Then we can direct them. If you are really concerned about that, your profit and loss, we'll direct them. No deviation, nothing. Whoever works, we will constructing it, it should be as per the specification and within the
This will, my lord,
stipulated period as per the
this will,
tender.
my lord, encourage them to perpetuate the illegality
I
that
don't
was.
know. As of the-
But
as
that's
of
what I'm,
now, I yet to-
that's what I'm pointing out, my lord.
Yes.
On the face of this document, whether the authority could have. accepted
Normally,
it.
that has been very fair. This court doesn't hear this much of long thing about the tender matter. What's there? There may be some, as you know, you are well aware, there may be some aberration. There may not be. Of course, if it is really seriously, if it is proved that they have fled a fraud and obtained the tender, then we'll interfere. But
In that
certain
case,
aberration here
my lord,
and there,
but to the,
we may not like to interfere
in that case, my lord,
unnecessarily.
to the extent of satisfying your lordship that some fake documents has been committed, let the writ petition be pending, my lord, and inquiry be, my lord, directed to be, my lord, conducted, my lord. And
No, that will
inquiry report
we'll
come.
have to decide, determine that. We'll determine it. Just on your sake, how can we direct for inquiry? We are not, nobody is stopping you to file an appropriate application. If there is a criminal angle and a criminal act committed by thing, nobody is stopping it.
Both perhaps also, my lord, in the.
But since you have started, you complete it. 15 minutes.
No, since your lordship is disinclining to see all this, then I'll conclude, my lord, only try
No,
to
no,
satisfy
no,
your.
I'm seeing it. 2 documents I have seen it. Proceed. What I'm requesting is to complete it rapid by 15 minutes. If it is the same thing, if new things are there. Yes, next. I'm not saying that I'm not inclined to hear you.
No,
But
since
let us see the.
Lordship has expressed the mind that even all these documents, on the basis of this document, Lordship cannot take a decision. Because inquiry has to be done or something.
No,
has
no,
to be
it's
done.
not
There's
that.
some
It's not that. That
lordship.
is why I'm yet to determine. We'll examine it. Obviously, it will not be decided in the open court. Judgment will be reserved.
That is there.
But want to finish?
I wanted to produce, my lord, the Form C, my lord.
Yes, produce it. Where it is?
It is at page 53.
53.
Lordship.
Sir, days are fun. You know that. Senior lawyers are heard 4 months together for a one matter.
Well,
This is also interest of the public.
Lordship, my lord, it can be.
Hearing a matter for many days, one matter for many days is not interest of the public. Page 53. Yes, sir.
Since the other matters are there, let them conclude. If required, we'll continue tomorrow, my lord.
No, we'll go for some time. We may, I think, this will have to spill over tomorrow because they will be placing.
Lordship, that's what I'm saying, my lord. Time.
So we'll continue for some time. Let us see.
I'll not take much time, madam.
115 minutes.
Other my lord, friends are waiting. That's what. My lord,
It's okay. I'll sit up to 4:45. Though I'm not keeping much good health. It's all right. Yes, page 50.
Page 53.
Yes.
This is a prescribed format. Form C.
Yes.
Details of eligible similar nature works completed during the last 5 years ending previous day of the last day of submission of the tender.
Yes.
The last date of submission of tender is 15/11/2023.
Hmm.
And the column 10 your lordship will see whether the works was done on back-to-back basis, yes, no.
Whether the work was done on back-to-back basis. Okay.
If it is back-to-back basis, then will not.
Page 53.
Page 53.
Form C, Form B.
Form C.
Form C, okay.
And the similar nature of completed during the last date 15/11/2023. Last date of submission 15/11/2023. Now Form C of respondent number 7 is at page 130.
Yes.
First of all, my lord will see the column 10 is missing.
Okay.
Column 10 is missing. Secondly, your lordship will see the serial number 1, the works that has been given. 80 crore 19,65,286.
Where?
That's it.
Column?
Serial number 1.
Yeah.
Column 4.
Yes.
80 crores 19,65,000 so and so. And date of completion is 18/10/2016. Now, as per the Form C of clause 1.7.2, it has to be within 5 years from the last date of submission of the tender. If it is reckoned back, last date is 15/11/23. So only the works which have been completed on or before 13/11/2018 can be considered.
Yes.
5 years. Now this is 18/10/2016. This could not have been considered. And this is the only eligibility for 63 crores. That minimum similar work required 63 crores. This is the only document to fulfill that particular clause.
1.7.4.
2.
Okay.
Where request 20% of the total bid value. That is 63.40 crores. Clause 1.7.2 A. A.
Small a.
Small a.
Okay.
It has to be 5 years reckoning back from the last date of submission of the tender. So it cannot be after 14/11/2018. So this has been considered.
Yes.
Now, after filing the writ petition, we have filing the writ petition, we came across a document where from it appears this document, your lordship will find this completion certificate is at page 131. Corresponding to serial number 1, this certificate that has been given is at page 131.
131.
131. This is the certificate issued by the executive officer, same executive officer, who is one part of the tender evaluation committee.
Yes.
And it is completion date shown to be 18/10/2016.
131.
And this
page 131.
121.
Completion certificate 17/12/2018.
17/12/2018. It is showing 18/10/2016. Same what he has mentioned there.
Completed the following works is that detailed below. Date of start, date of completion, 18/10/2016.
Now, this certificate with regard to my lord subcontracting, it is not that work has been done by him, therefore clause 10 has been deleted from the form C by him, because this is a subcontracted my lord works which is mentioned in the certificate itself.
Okay. So he has deleted the clause 10
Clause 10,
or omitted to fill up that.
lordship, my lord. And this certificate he has shown, my lord. Now we have come to a document if your lordship takes up the IA, my lord, where this document has been given at page 22.
Yes, IA.
IA page 22. 22.
Hmm.
This document was part of the review as well as writ appeal, my lord, and the fraud question, all these things have come consideration of this also, my lord. This has been issued by the, my lord, NHIDCL. Lordship may come to page 23, serial number 2.
The specific complaint that the clause certificate submitted same was verified from the issuing authority in this petition. Hmm. Yes.
Has your lordship gone, my lord?
This is issued by whom?
This was issued by the, my lord, executive engineer Naharlagun division. No, this particular letter was issued by the NHIDCL. This certificate that we are referring to, this also mentioned here. Because he has produced this document with a contract with NHIDCL. So they have made the inquiry with the executive engineer, and he writes this serial number 2. Whereas there were a specific complaint that the enclosed certificate submitted by Messrs. Kange Construction for subject project is false. Hence, the same was verified from the issuing authority in response. The issuing authority, that is Executive Engineer Naharlagun Division PWD AP New Delhi White letter number so-and-so dated 22/12/2021 informed as under. In response to your letter numbers referred above, it is to inform that the work completion certificate White number so-and-so dated 7/12/2018 issued to Kange Construction Company against the work 4-laning Hangali Holongi Itanagar total 19.20 NH 52A in the state of Arunachal Pradesh of SA RDPNE has been cancelled under clause 2.4 of contract agreement White number so-and-so dated 29/5/2019 and the work experience certificate against the work double laning of Papu Ajib so-and-so is forged and unauthenticated.
But then,
so this document is forged and unauthenticated. That's what has been said.
Blacklisted for
No,
1 year.
No, NHIDCL for this reason has made the non-performer or so, that is
No, blacklisted.
That is lordship. That is
He has not replied.
No, that is a different issue, my lord. But what I am trying to highlight here, that the executive engineer has cancelled that document. I am not only non-performing. Executive engineer has cancelled that document as it is forged and unauthenticated.
As per the NHDCL. Huh?
My lord?
As per the NHDCL notice.
Lordship.
Yes.
Here, the response of the government, they have filed the affidavit in opposition to this IA. There they said, we are not concerned whether he has been declared non-performer by the NHIDCL or not. But we are not on whether he has been not declared non-performer or not. But the same executive engineer has said there that document has been forged and withdrawn, cancelled. Now this we have pointed out.
These are the documents on the basis of which he was awarded the award.
That is the document, the completion certificate. First of all, it is beyond the 5 years period. Secondly, that document has already cancelled by the executive engineer, which reflects in the NHIDCL. This has not been denied by any of them, my lord. The private respondent has also filed affidavit, and then, my lord, government also has filed. Rather,
Yes.
the government is saying that he is having other eligibility, my lord, document.
So this has not been taken note of. This has not. It is not the documents.
No, they have taken note of it, but
On
other
which?
than leaving this also, he is having other document to show his capability. But that document was never a part of the bidding document.
Okay.
This is not set up by the private respondent also. But you will see the department is more interested in retaining the order. Department is more interested in retaining the order than the private respondent. He is not saying that this document, I am not, the cancellation or the.
Where do you find, even if clearly the mistake or the illegality is committed, where and which case and under what circumstances the respondent authorities will admit to that yes, we have committed a wrong.
My lord, moment it has pointed out because the clause is there, because at any time if fraud is.
Obviously, they'll try to support their action.
No, my lord.
Wrongly or rightly.
Wrongly or rightly, my lord. But the clause says the moment the
So
fraud
if you are showing it, if you
forgery
pursue-
or fraud if
if you-
committed. Clause says.
If you persuade the court, that's all. They'll never admit. Once they admit, matter ends there. So they'll never admit. Even if there is a glaring illegality, no one will admit. That's why we have to determine.
Yes, but our reference from the letters, what says that particular document has been withdrawn. First of all, it is beyond the time. Secondly, this document was cancelled. It could not have been submitted. Non-performer, performer, we are not on that. And the clause of, one of the clauses.
Yes, I have understood.
Lordship.
They have issued, the person who has issued the certificate has, as per the NSGSL, that the person who has issued the certificate has said that it was forged and it was unauthenticated.
Lordship. And same person in the technical bid also, same PWD, my lord. PWD only, under the same, my lord, superintending engineer or the executive engineer, same division, my lord.
From where they have got it, we don't know.
Gotcha. Now, in support of that, the government has, my lord, come up at page 32.
Of what?
Of the affidavit in opposition filed by the government, my lord. In IA.
This is in IA.
In IA, my lord. IA, my lord, I have filed.
IA were considering only for the purpose of looking at the documents.
Yes.
Not otherwise.
Yes.
Yes.
They are supplementing their
Affidavit
argument
opposition
by the government.
who is objection come affidavit no.
Reply filed by the state respondent number 3456. I number.
Respondent number 3.
3456.
Yes, yes.
They are page 32, your lordship will say.
You have also not submitted your registration certificate.
Yes,
Yes, class
this
1 AA.
Yes, this objection was never raised in the, my lord, affidavit in opposition filed by them. First time they have raised here, I have answered to that also.
Page 32.
Page 32.
What does it say?
But this is a certificate with regard to the work, Lordship will see establishment of new medical college attached to his district referral hospital at Naharlagun, Arunachal Pradesh. Kenge. He has constructed this work, worth about 161 crore. This was never part of the bidding document, nor the works of building was sought for. It is only roads and highways were asked for. Now government is supplementing this document instead of the earlier 2712, saying that he is having the capability. And the contents on your lordship will find at page paragraph 4.
Yes.
They are trying to supplement this. The contention has been given. So far as private respondent is concerned, he is not aware. He has submitted the document. They have given him the.
These are the only documents.
These are the documents. He's
Only documents.
Whatever is there is
No
there.
more, no more.
No other document. For me. Me to point out.
So basically, interpretation of 1.7.4 and the for rejection, according to you, this Form C, Form D, I mean the what is
Schedule D.
Schedule D, C, D has to be followed. In case if Schedule D is followed, you are eligible, whether you have 158 or not. To find out whether you are eligible, you will have to go through the Schedule D to show that whether you are eligible or not. Just because as per the your own interpretation, if it is not annual average of 158.50 crores during the last 5 years, you just cannot reject it without resorting to the Schedule D.
That is my second.
That is first. That is first.
No. First
second is
First is that the 17.4 what it signifies is 1 year's annual turnover in 5 years.
That I've said.
That
That
is
is
my-
a matter of interpretation only. It is not 5 years average turnover.
Yes.
It is 1 year.
1 year.
That is your interpretation.
That is my
Wrongly interpreted.
They have said average. Now, what I said, even if it assumed that the average of 5 years is required, in that case also, there is no clause in the tender to reject for this particular not having 158 crore average, because you have to go through Schedule D. Schedule D marking patterns are there, read with SOP 24.
Yes.
That is my case.
That's your only case so far as the action of the state is concerned. As on that stage. Now you are saying that the respondent authority has awarded the work on the basis of the fake and false documents submitted by the respondent number 7, including those
distorted Form C, what is C?
False, distorted, everything.
Everything, all sorts.
False, distorted,
Yes.
fake.
Yes. Including UDN number, everything,
Yes.
Yes.
And one of the certificates, admittedly, the NSDCL has issued a notice to the author of that certificate, and he has clearly said that it has been fabricated, unauthenticated.
And the tender clause 6.2, just 2.6.8 page 38,
Yes.
Page 38, clause 8. Bid uploaded with fake or false document if established during evaluation scrutiny is liable to be rejected without any information and cannot be challenged.
Page 38. Bid uploaded fake or false document if established during evaluation scrutiny is liable to be without any intimation cannot be challenged. This may not at this stage applied because As on today, they are not saying that was there any fake or false document. They are rather defending.
They are defending.
So
What my
there is no question of invoking this clause.
No, this relying, that means.
Can you show that at the time of evaluation, did they have the knowledge of having a forged and fake documents? No.
My lord,
This
when
is you are trying to establish now.
No, not that. But what I'm trying to say, that before accepting these documents, the authority have to scrutinize the documents of each of the tenderers.
Loaded with fake or false
Each of the
documents
tenderers.
established. During the evaluation and scrutiny,
Yes,
is liable to be decision without any influence, cannot be challenged.
they have to scrutinize these documents. They have to authenticity, they have to see. And if they found that can be rejected, now even that has been escaped
How
their
can they
notice.
say that it cannot be challenged?
My lord?
How can they say that it cannot be challenged? If everyone is agree, they can challenge.
They can challenge, my lord. My contention is that they ought to have, my lord, verified all these documents, which one is fake, this, that, and all, each. and-
Obviously, they will not.
Yes. So they have not done. Now, even having, my lord, pointed out to them, they are not doing anything, rather supporting.
So therefore, now this is not a stage to invoke this clause, 8, page 38. Because it says, at the time of, during the scrutiny or evaluation, if they found that the fake and false documents have been uploaded, it will be rejected without intimation. That stage has gone now.
Now, my submission is that Lordship will see whether they have scrutinized this document or not. If they not, they will scrutinize now, if required. Then, my lord, they'll take an action, because these, all the materials available in the records are there, my lord.
Let's start, man.
We will continue tomorrow.
Well, tomorrow will be difficult. Man. I'll take maximum 15 minutes, man. 15 to 20 minutes. You will kindly hear me, man, because I'm from out of station, man. I'll have to go back today.
You stay back tomorrow, we'll hear you, we'll continue.
Lordship will hear me on online.
Day after
on
tomorrow,
PC.
in that case. Huh?
Day after tomorrow, there is a part-head matter fixed in Guwahati.
So we'll do it tomorrow, 15 minutes.
Lordship will take it up kindly, man. I kindly urge upon your lordship.
See, we'll have other, all methods also, we'll have to finish this. In any case, why am I adjourning it? Because in any case, will not be complete, we'll have to hear the government also.
My lord, at least my part, if
In
it is
fact, government will hear the first government.
if my part is complete,
Your
man.
part will come later, we'll hear the government first. We'll take up tomorrow.
Lordship will kindly permit me by VC, man.
It's up to you, we cannot reject it, but will not, we're making it very clear. We're not comfortable with the BC because of the technical problem. We miss everything, but we cannot reject. We cannot reject your prayer, it's up to you, but practically we're not comfortable.
Kindly
There's
permit
a
me to-
difference of, there's a lots of gap because of the technical thing which you are using, because of the infrastructure, right? We'll hear the government first. You are the beneficiary of the government's action and inaction.
No, there are
All
clear
right.
clauses, my lord. I could have shown, my lord. Learned friend is saying that there is
Yes,
no clause.
I'm not saying we'll not hear you.
My lord,
Then tomorrow, we'll continue tomorrow. Heard Mr. PJ Shekhar, Senior Counsel, assisted by so and so, learned counsel for the petition. Hearing remains inconclusive. List for further hearing tomorrow. Mr. Estafin, learned Senior Counsel, Senior Government Advocate for the state, as well as Mr. Ndeka, learned counsel for the respondent, shall be heard tomorrow. We'll finish it tomorrow. And if possible, to make it easier for this court, you can submit a written submission, all of you, so that everything is taken care of. Otherwise, if we keep it CAB, the oral, though we try to record it, we miss the.
yes,
points.
written submissions may not be possible tomorrow. Lordship will give us 3-4 days time, my lord.
Okay, well, it's up to you. Yes, what is to be done in this matter?
On several occasions, this matter has been listed and subject to convenience of your lordship. My lord, the matter can be heard in. My lord,
Can we have it tomorrow, Your Lord?
We cannot all the cases tomorrow. Because this should have been given, that's the reason I adjourned the other matter. Should have been given preference. You are ready for hearing?
Yes, ma'am. And if not today, then day after tomorrow, ma'am.
We'll try next week.
Next. All right. Okay.
On the
Otherwise,
prayer of learned council today. What is list this matter for hearing next week? After a week, we'll see.
My lord.
We'll try to give this preference.
My lord.
2014 matter.
Definitely.
May I, Your Lordship? Your
Yes.
Lordship, the conducting council, for some urgent reason, was not able to appear today, Your Lord.
Why?
That I was not informed about, Your Lordship. But it may be fixed for tomorrow or day after tomorrow.
Cannot fix all the matters in a single day. And Mr. When M. Kato, learned counsel for the petitioner. I have a reservation in this matter.
My lord.
It was converted to CRP. It was a first appeal,
First appeal.
converted to CRP,
Yes.
civil revision.
Civil revision.
And Mr. M. Kato, learned counsel for the. Mr. E. Pai,
Yes, Your
learned
Lordship.
counsel for, counsel appearing on behalf of Mr. T. Patil.
Yes, Your Lordship.
Learned counsel for the respondent.
Sorry.
Submits that the leading, the outgoing counsel, Mr. T. Patil, is indisposed today, for which he prefer for listing the matter after 2 weeks.
Well,
Whereas,
Deeply obliged.
a prayer not being objected to by learned counsel. Petitioner Mr. M. Kato, whereas allowed list this matter after 2 weeks.
Deeply.
Deeply obliged.
Then 28 adjourned, 28, 29. Yes, 29 and 30.
29 and 30.
Yes, we'll hear you.
Your Lordship, in this matter, Your Lordship, standing counsel, Tagum Jamo is here, Your Lordship, for IMC. He's the man,
Huh? Is Jamu for what?
for standing counsel for IMC, Your Lordship, is the main party.
M. Patil?
Main part, he's the leading.
Hmm? Who is appearing?
I'm appearing for Deputy Commissioner, Your Lordship, for,
Yes,
for IMC, Your Lordship.
yes. Then? Who is appearing for what? Whom?
My lord, I'm for petitioner.
For one, Your Lordship, I'm appearing, Your Lordship,
Yes.
for 1 and 3.
The impute order has been passed by Deputy Commissioner only as an administrator. Who appears for IMC? Is it IMC, something like that? Huh?
Tagum Jamo, Your Lordship.
Where he is? Secretary, Town Planning, Urban Body. Who is appearing for? You
I'm
are,
appearing, yes, Your Lordship.
then you are 1 and 2, 1 and 3.
Yeah, 1 and 3, Your Lordship.
Oh. Who is this respondent with 4 and 5?
My lord, is IMC, my lord. Chief Executive.
By name, you have given it by name.
Olik Taring. He is the ex-chief executive municipal official.
And another one, 5 is keeper.
Notice served,
Yes.
notice completed,
Yes, yes.
then
My
Where it
lord,
is?
my lord, my case is very simple, my lord.
very simple, you don't have case.
My lord, I have been terminated without issuing notice, my lord. That is my case, my lord. Without
There is no post, nothing, no approval by the government. How can you be appointed? Your appointment is illegal. Ab initio.
my lord. My lord, I have been advertisement has been issued, my lord, and work interview has been conducted, and wherein I have been appointed, my lord.
Where you show us? Where's the advertisement?
My lord, page 17, my lord. This is the advertisement for work in interview.
Hmm?
And it has been I have appeared the examination, working interview in the examination, and I have been selected, my lord, and accordingly I have been appointed. And thereafter, when I was in the training, my lord, all of the sudden a termination order has been issued, and that I have only seen the newspaper, my lord. That's why, my lord, I came before this order without. This is the violation of principle of national justice, my lord. Without hearing me, my lord, they have been terminated me.
No, entire selection process were cancelled because there is no sanction force, there was no post, no approval of the government was taken required under the act.
Regarding the procedure, my lord, my lord,
So your process
I cannot
itself was
comment, my lord.
wrong.
My lord, my lord, regarding the post, my lord, Deputy Commissioner has also not mentioned that there is no post. Just without due procedure, appointment is illegal. Only that what has been given in my termination letter. my lord.
Where is the termination order?
My lord, it has been published in the newspaper, my lord. Page 20, my lord. It has been learned from the various sources that some training of the candidate whose appointment were cancelled by the order number this, dated this, which were also published in the newspaper dated this, is ongoing at the Guwahati, Assam. It is hereby brought to the notice of the general public that the appointment orders of this candidate stand cancelled due to the procedural lapses in other regions as mentioned in the aforesaid paper order. Hence, any such training is illegal and ab initio. And general public is hereby advised not to take part in such illegal training. This public notice is issued in the interest of the innocent candidate to prevent them from being cheated by unscrupulous element. My lord, I'm an innocent candidate, my lord.
Where is the interview? Where was the interview conducted?
Interview conducted on advertisement of interview is it's page 17, my lord.
That is the problem. Only as a IUS advertisement was issued, there was no post, nothing. And then appointment orders was issued. In the interest of public service, so and so is hereby appointed as so and so. What does it show that advertisement was issued? An interview was conducted, nothing.
In the appointment
You
letter.
pursue the better thing. regular job, not this sort of appointment. And Mr. Odugo, learned counsel for the petition. And MS P. Pang, learned counsel for the respondent 1 and 4. 1 and 3.
Mr. Lordship, 1 and 3.
It is informed that the Mr. T. Taba, who is appearing for IMC.
IMC, Your Lordship. Tabum Jamo, Your Lordship.
T. Jamo
Yes, Your Lordship.
appears for respondent number 2. However, he is absent today. In view of the above, let this matter be listed on 31st 07/2024. Mr. The learned counsel for the petition as well as the state council undertakes to inform Mr. Tabu. T. Jamo. Learned counsel for respondent number 2. That the matter shall be taken up for hearing on 31st. You inform them and we'll take it up.
Organize, Your Lordship.
Item number 31.
Lordship, I am for the respondent. Respondent number 1.
Yes. What is to be done?
The appellant counsel is absent.
Huh?
Appellant counsel is absent.
What is to be done? You are for respondent number 1 and 2. I mean 2 and 3.
No, Lordship, only one. For the insurance company, Lordship.
Who is for 2 and 3?
Lordship, 2 and 3 is unrepresented, Lordship.
2 and 3. For publication. For publication. Considering the notice of response which have been served to the paper copy. Is there any record of paper publication? For this one. Don't appears for the petition or. Appellant. Mr.
Thank.
Now the council for responding one. Is present. It's the matter of 3 weeks.
Understood.